Yes, Mr. Shaw.
Lordship, this item number 34, Lordship, remember the principles. Lordship has passed an status quo order. That day I have clarified, Lordship has passed the status quo order. Lordship said yes. And in the order, there is a status quo order.
There is a
Now, Lordship, they have started the proceeding against Dino, against me.
How can
During dependency, Lordship, I have filed an affidavit.
I think I have passed the status quo order.
I will be allowed to call for that.
Please do.
Affidavit, Lord.
Please do so.
And that too, with the instruction of the Council for the Education Department, they have written. This is very unfortunate, my lord. This type of thing would be IS officer.
I think we passed the status quo order.
Yeah, there is a status quo order also.
Okay.
May I please, your lordship? Lordship.
Mr. Sharma, it is a matter pertaining to the law college.
Yes.
So the interpretation might be a little bit higher.
Lordship.
May I please, your lordship? Lordship, in item number 22, lordship, respondent has filed their affidavit in opposition and we have also filed our reply, lordship. That has not been on record, lordship. Lordship, my record may be called for, lordship.
Yes, yes, we have it.
Lordship.
We have it. Hey, we have it.
Lord.
Don't worry, it will come. Malakaratma. Hey, Malakaratma. What do you matter? Yes.
May I please, I beg to mention item number 10, my lord. My lord, senior counsel, Mr. C. Chaudhary, my lord. Item number 10 may be taken after 2 weeks, my lord.
On the prayer made on behalf of Mr. C. Chaudhary, Learned Senior Counsel, appearing for the petitioners, list this matter after 4 weeks.
I'm for the
Master
respondent
blessing.
ASTC.
Huh?
Respondent
Respondent,
ASTC.
my lord.
You are for the ASTC.
Yes,
ASTC.
sir.
You are Mr.
M. Sahewala.
M. Sahewala. Mr. M. Sahewala, Learned Standing Counsel, Transport
Man.
appears.
ASTC, man.
Standing Counsel, STC is present. 4 weeks, huh?
Master blessing.
Deeply.
May it please your lordship.
Hmm.
My lord, may I pray for listing of a matter? It concerns that correction of date of birth. My lord, I've heard it some
Next week. Next week.
next week. A further request, my lord, subject to correction. Item numbers 1 to 7 are for delivery of orders.
Hmm.
My lord,
You have one there.
item number 7
Ah.
is mine. So far as item numbers 1 and 2 in court number 7, motion matters that it would take some long. In case my lord,
Don't
digging
worry.
the orders.
I'm not in a position to deliver the orders today. But I have the other two are literally tied up with around 40 matters which have been corrected today. So they will not be able to. So she is very new. She won't be
Lordship.
able.
So item
I'll
number
have
7,
to distribute this.
I
later.
seek an accommodation, my lord.
We will.
I may
accompany.
not be there, my lord.
Other than item number 5, with Mr. Soikia wants to argue
Lord.
today, other matters we will give dates.
So my colleague would be there. Obliged, lordship.
May I please, lordship? We have for listing lordship to contain matter lordship.
May I please, your lordship? Lordship, with petition for listing, lordship.
Next week.
Next. May I please, your lordship? I beg to mention for listing, lordship.
Please. Any listing matters handed over to him.
Much only.
Hey, 1, 2, 3, Mr. Monto.
Hello.
We'll have to have an accommodation today.
Madam,
Can't help it. She won't be able. Others are
Madam.
tied up with a big backlog. So we'll have it. We'll give a few dates and we'll,
Madam.
if possible, we'll pass the orders.
Deeply.
Take it up 1, 2, 3, 4, 6, 7, 7. 1, 2, 3, 1, 2, 3, 6, 7, 1, 2, 3, 4, 6, 7, 7. Not right now. It would not let you go. I'm not worried. Completely all right. Get in a routine. Pass them to my.
Deeply.
In the item number 6, I have an instruction, madam. Yes.
Item number 6.
6, yes, madam.
Yes, what is it?
Yes, madam. Item 6. You want the intermediate?
Okay. Item number 1. Episode 2, 3, Belik Mariba. Episode 4. Episode 6. Episode 7. The delivery of orders in the present cases are deferred and the matters are directed to be listed on dash custodian for delivery of orders. Item number 5. So, Mr. Soikyar, AG wanted to argue this matter today. He wanted to make some submissions. Otherwise, we were drafting it. We were dictating the thing that he wants, that they made a prayer that he wants to make a mention. Mr. Sharma, can you just inform Mr. Soikyar, AG? Whenever he is there, with the convenience of Mr. Senior Advocate, if he can come, we'll take up the matter. Mr. Soikyar, be relaxed. When he is here, they'll inform you. You also come. Yes. Ready. Matters are ready. Files is ready.
No, we have filed our affidavit. My learned friend has also filed it.
No, from the records, what do you have?
Take up my affidavit. Approximate 4 queries to the university.
No, their affidavit is there. 9th itself, you had filed it. Yes.
Approximate take into consideration. Because our contention is that he was entitled to fellowship and he was granted as per rules.
Just switch on the mic. Yes.
Approximate as per the government made by the registrar.
Sound from yes.
No, Lordship.
No. Sound. Yes.
Lordship may take up our affidavit. Filed by the registrar, Lordship.
Yes, please.
Paragraph 3. The respondent with regard to point number 1, 2, and 3 has ordered it as of December court. The innovation of the science pursuit for inspired fellowship shall be eligible to candidate pursuing full-time PhD course in recognized university. Also, the candidate is to submit PhD admission letter, note PhD registration certificate to furnish agency after receipt of the provisional offer of the fellowship. The Inspired Fellowship in Guidelines, February 2015, applicable to Sri Devendu Saha is as follows. Eligibility condition has been mentioned. Then the Inspired Fellowship second minimum 60%, 65% marks, aggregating to equivalent of CCPA at MSc or integrated MSc or MSc course. First rank holder, then Lordship Sri Devendu Saha was first rank holder and was awarded gold medal for securing.
You can come to page 342, paragraph, the second paragraph there.
Page?
Page 342. The paragraph 3.2. 3.2. Second paragraph.
The PhD admission of Sri Devendu Saha is guided by UGC Regulation 2009. As per UGC Regulation 2009, students who are admitted to MPhil PhD programs, having been admitted to the said program, students have to go for coursework for minimum period of 6 months. Hence, admission into integrated pre-PhD course would also mean enrollment into PhD program. As such, there is no other admission process in the PhD program.
Here you are saying that the integrated pre-PhD would mean PhD.
Yes. Then Sri Devendu Saha has taken admission to PhD program on 11/1/2016, which means enrollment into IPP program. And Sri Devendu Saha received Inspired Fellowship on 11/3/2016. Other students also received the Inspired Fellowship for which the date of admission of PhD program. Then we have managed the list. Then
But is that the prescription in your regulations?
okay.
Is that this prescription in your regulations? Your regulation says something else.
Regulation it is not.
Huh?
In regulation, probably it is not.
Pardon?
In regulation, this particular, because we are guided by the notification of the UGC.
How can you? You have made that regulation. Show me that that regulation is obsolete. You are not following it.
No, that is not the question.
Then-
Lordship, regarding the PhD admission. Lordship, time
There
to
is
time-
two parts. One is pre-PhD, one is PhD.
Lordship,
If that person does not complete that 6 months or something IPP,
then he's not entitled to it.
then how will you give him the Inspire scholarship from the date the IPP was gone into? That is the issue.
Now, Lordship, may I please to see paragraph 3.3.
3 point? Huh.
The Divyendu Shah submitted his acceptance letter
No dispute on that. You have paid him.
and petitioner has endorsed thrice though. If he was not eligible, how could the head of department?
Forget the professor. Why did your register allow it? Your register.
Because it was allowed by the head of the department.
It was allowed by Mr. Doctor first.
Yes, Lordship, the process was there.
Doctor, then it went to Mr. Nath
No.
and thereafter to you.
And I made a note, only note.
And he has thrice he has given his approval.
So now your stand is that IPP is enough.
Yes.
Okay, fine.
And Lordship, with regard to that EGC regulation of the EC, Lordship may come to paragraph 4. So before that, paragraph 3.3.
Paragraph 4.
Paragraph 4.
3 point?
Lordship has said that why disciplinary action has not been taken against him. Lordship, to appreciate this, Lordship, may please go to paragraph 3.3 also.
3.3?
3.3,
Yes, I'm on that.
that Sri Devendra Shah submitted acceptance letter to the Assam University for applying Inspired Fellowship, duly signed by the supervisor, forwarded by the then HOD, Mathematics Professor Samir Vera, the petitioner. With that, Sri Devendra Shah submitted his final application for Inspired Fellowship. That on 8/11/2016, Sri Devendra Shah got sanction order for DST for fellowship amount for 1 year, which is 3,50,000, and the fund was credited to university's account. That Sri Devendra Shah applied for fellowship of 9 months, and the claim form was duly signed by the then HOD.
So, Mr. Gal, this court has to now draw a conclusion that you're giving it for 9 months. That is beyond the period of the IPP. So we'll have to draw a conclusion that any person who is getting into that IPP will go into that PhD course. That conclusion also we'll have to draw. Okay.
Then Lordship, further, the Devendra Shah again applied for fellowship for 1 month, and claim for form RF3 was again duly signed by the then HOD Mathematics. So it seems that the petitioner knew that the fellowship was genuine, and that is why he signed earlier claim forms. Next please. As per the minutes of 121 EC by resolution number so and so dated 12 July 2018, the council.
Okay, your explanation for not drawing the proceedings.
Yes, that is there. Lordship. The next paragraph, Lordship, the university did not violate any natural principle of law, as because the EC has acted while considering the merit and to the best interest of the university. The university did not take any disciplinary proceeding against Professor Samir Vera, and during the period his long leave, he was paid his salary and other benefits. Hence, it is said that this is the explanation. Lordship.
Okay. Yes, Mr. You have anything more to add?
He's on the shoulder of Mr. Cohen.
Huh?
He's on the shoulder of Mr. Cohen.
My lord, I'll take 5 minutes.
You take full day. There is no problem. We are with you.
First of all, 5 minutes. My lord,
Because the thunder may fall on you.
my lord, short summary of the case by respondent.
9, it's with me.
And my lord, I'll just go through.
You
the-
highlight. I've gone through it. You
My lord,
just highlight.
I'll just reiterate, my lord. Your lordship will kindly allow me to reiterate. Respondent number 9 completed MSc in the year 2014, getting first class first, a gold medal. Thereafter, he applied for Inspired Fellowship. Thereafter, he was provisionally enrolled for PhD and for Inspire Fellowship under the 7th advertisement 26/4/2015 with 3 choices of supervisors and institutions, among which respondent number 8 was top priority. Thereafter, my lord, respondent number 9 got provisional offer of Inspire Fellowship on 19/10/2015 as he was required to take admission in PhD within 1 year. Respondent number 9 took admission in integrated pre-PhD program of Department of Mathematics, Assam University, Silchar on 11/1/2016 as per UGC guideline. To apply for Inspire Fellowship, an endorsement form was required to assign the supervisor. At that time, respondent number 9 applied before the registrar of Assam University and it was forwarded by the petitioner. The endorsement was signed on 20/1/2016. With that, respondent number 9 submitted final application for Inspire Fellowship. On 11/3/2016, respondent number 5 awarded final offer for Inspire Fellowship to respondent number. This is vital, my lord. Respondent number 5 is the sponsoring authority. It is the funding authority, Department of Science and Technology. Respondent number 5 awarded final offer for Inspire Fellowship to respondent number 9, and he was to submit acceptance letter to respondent number 5, which was duly signed by respondent number 8, the petitioner, and the registrar of the university, and was submitted to respondent number 5 on 11/4/2016. On 8/11/2016, respondent number 9 got the sanction order from respondent number 5 for fellowship amount of 1 year of rupees 3,50,000, and the fund was credited to university's account. On 11/12/2016, respondent number 9 applied for fellowship of 9 months, that is 11/3/2016 to 10/12/2016, and the claim form RF3 was duly signed by the petitioner. On 16/1/2017, respondent number 9 applied for fellowship of 1 month, that is 11/12/2016 to 10/1/2017, and the claim form RF3 was also duly signed by the petitioner. On 9/3/2017, respondent number 9 got provisional registration for PhD. This is again important. This date means registration into PhD, not admission, my lord. Got provisional registration for PhD. His registration was also delayed by the petitioner as he did not conduct the registration seminar on due time after the IPP result was published. On 11/3/2017, respondent number 9 submitted claim form for fellowship for remaining 2 months and for the contingency amount. This time, the petitioner did not sign the claim bills and showed no reason for that. This way, 4 months had gone and respondent number 9 had requested the petitioner repeatedly, but the petitioner did not sign, also showed no reason for that. On 27/2017, respondent number 9 wrote to Dean, School of Physical Sciences for release of fellowship. On 25/7/2017, the petitioner asked respondent number 9 to mail him the procedural details of his fellowship, and respondent number 9 accordingly sent the mail. On 2/8/2017, respondent number 9 wrote to the Vice Chancellor for release of fellowship, and based on that application, a one-man committee of Dean, School of Physical Science inquired into the matter and recommended to release the fellowship to respondent number 9, and the petitioner was informed about the same on 1/9/2017. But this time also the petitioner did not sign. On 28/11/2017. The respondent number 9 again wrote to the Vice Chancellor with a self-declaration to release his fellowship and explained his sufferings for last 8 months. The Vice Chancellor forwarded that letter to the petitioner, citing it as urgent, but even then the petitioner did not sign. On 21/12/2017, the respondent number 9 got a copy of a letter which was addressed to the petitioner from the Assistant Registrar Research, and in the said letter, the petitioner was instructed to sign the claim bills. With that letter, the respondent number 9 again submitted his claim bills to the petitioner on 3/1/2018.
It's okay, Mr. We have gone through.
So, my lord,
You have delineated. Now, just tell me one thing.
my lord,
There are 2 stages here.
my lord.
One is that pre-course. You are otherwise eligible. You are the first class gold medalist. You are eligible because the university requires 55%
My
marks for this
Well.
PhD course.
My lord.
Now, after you have to go through that IPP. You
Yes.
also had to go.
Yes.
After the completion of the IPP, was there a interview held for the PhD?
No, there is no such procedure, my lord. The
You
procedure,
come to page 37,
page 37 of
ordinance,
the annexure of the writ petition.
writ petition, annexure 1.
Yes.
Come to PhD admission and eligibility, second paragraph.
Your lordship is referring to page 37. A candidate who secures less than 55.
No, you come to admission to will be once or twice in a year, preferably after announcement of result of the integrated work course.
Yes.
So the ordinance compartmentalizes the thing into two compartments, distinct compartments.
So far, this ordinance is concerned. But at the same time, your lordship has also seen the regulations that has been annexed.
Come to that.
Now, in the regulation, your lordship will kindly take up my affidavit for a while once again, madam. Now, the university has clarified that I am.
And when we are with the annexure, please also come to page 39.
Yes. Yes, my lord. This is the,
General terms and conditions.
yes.
This is the Inspire College
Yes.
fellow guideline.
Yes, 2000.
Fellowship shall be available only for pursuing full-time PhD program in any recognized so-and-so in the country.
Yes,
So full-time.
full time.
This
So-
along with next page, can read along with next page. Serial number 2. Please,
Fresh
read, within one,
applicants.
please.
Are you on that fresh applicant part?
Yes,
Who have
entire
taken,
paragraph.
huh?
Entire paragraph. Let me read.
While availing so-and-so.
Yes,
That would be
Effective
as-
date.
taken-
Effective date.
The date of acceptance,
yes. When it will be after taking admission in PhD. That is the effective date.
Fine, Mr. We got
Right.
it.
Next one. Applicant who shall be placed under provisional selection, registration category during the selection process and subsequent issued final order by gaining admission into PhD or by virtue of accepting representation at DS level. The date of issuing final order will be effective date. That means you get admission, then you apply,
We got
then they accept. And the last line, for final selection under Inspire Fellowship, admission into PhD program is necessary.
We got it, Mr. Nath. Yes,
No.
your affidavit.
No, my lord, my
Paragraph?
affidavit. That is the regulation 2009. Now that the university has clarified that the respondent number 9 will be governed by the regulation, UGC regulation of 2009. So the regulation at page 22, the internal page. Now, your lordship will kindly take up page number 22 for a while. It starts from page 22, it continues thereafter. Now, your lordship will kindly see page number 24.
Your annexure.
This is annexure 1. starting
This is
from page-
5/5/2016.
Your lordship is taking my affidavit in opposition. The
Rejoinder.
no, affidavit in opposition by respondent number 9, my lord. This is dated 25th October 2018.
285.
The very first affidavit in opposition.
Okay, got it.
Now,
You
As-
want to have?
the regulation, UGC regulation starting from page 22. I'll take your lordship to page 24.
You have filed 2 affidavits.
Yes. That's the very first affidavit, my lord, in point of time.
Can I just have a
Yes,
copy?
yes, my lord.
Okay, yes,
Yes.
proceed.
My lord, you will.
Page 22.
Yes, and my lord will come to page 24. Your lordship will kindly take up force work. Page 24, my lord has got.
24.
Yes. I'm talking the internal page, my lord. My lord will have my copy.
I've read it. I know. I've seen it yesterday. Just a minute. Here's something. No.
The regulation starts from page 22. I have, my lord, referred to page 24.
Coursework.
Coursework. After having been admitted, each MPhil PhD student shall be required by the universities, institutions deemed to be universities and colleges and institutions of national importance, as the case may be, to undertake coursework for a minimum period of 1 semester. The coursework shall be treated as pre-MPhil PhD preparation and must include a course on research methodology, which may include quantitative methods and computer applications. It may also involve reviewing of published research in the relevant field. The individual universities, institutions deemed to be universities and colleges, institutions of national importance, as the case may be, shall decide the minimum qualifying requirement for allowing a student to proceed further with the writing of the dissertation. If found
Dissertation
necessary-
comes once you get into that PhD.
Yes. If found necessary, coursework may be carried out by doctoral candidates in sister departments,
Forget that.
institutes, either within or outside the
So
university.
this is a requirement under 2009 that before you get into a PhD program,
Yes.
you must have a pre.
My lord, the language
It's
is-
called as
the very first line, my lord, after admission.
after having been admitted.
Yes.
Each MPhil so and so, okay.
I am on nothing else, my lord, only this, because the university says I am governed by 2009 regulation. 2009 regulation says that after being admitted, I am to go for a 6 months course, which is a pre-course. Now, thereafter, there is now this ordinance. Now, whether in case of there being a discrepancy between a regulation and an ordinance by the university, my humble contention is the regulation will always prevail, my lord. Because ordinance cannot be
No, it
in
cannot.
contradiction, in contradiction with the regulation. So if the regulation prescribes, and based on this regulation, my lord, one other aspect which has discerned from the affidavit filed by the Assam University is that on similar lines, the same process has been followed in case of other candidates as well. So
That is the statement now made.
this is the statement that has now been made on affidavit, that on similar lines, the other candidates have been also dealt with insofar as providing of inspired fellowship is concerned. And my lord, here, my argument here would be that sponsoring authority, the funding authority had never raised any dispute, any complaint against
The
respondent number
counter
9.
argument to that by Mr. Nath would be because that authority was never apprised of the actual facts.
Exactly.
My lord, that-
Subject to your UGC regulation 2009,
My lord,
that line.
my lord, pre-filing of the case, agreed. After filing of the case, also there is nothing from respondent number 5. Respondent number 5 is a party.
If they have not come up, how can we, in absence of any material indicating to that extent,
My lord, that is my
come to that? conclusion?
my limb of argument, my lord, that since there is nothing from respondent number 5, locus standi of petitioner insofar as pointing out, my lord, my entitlement or disentitlement to the fellowship, that perhaps doesn't hold good. In my
He has not, see, he has not come up before this court challenging the grant to you of the fellowship
exactly, my lord.
or your PhD.
Exactly, my lord.
He is here because of your complaints or complaints made on your behalf by the students union, the effect on his service. That is why he is pointing it out that, see, I am not at fault.
Not only
What-
students union, the word favorite students union.
My lord,
No, whatever it is, that is Mr. Nath's
My-
prerogative. He can say anything.
my lord,
I can't say something.
my lord, to this,
But be that as it may.
my lord.
Now, once that is brought before this court, to understand whether he had deliberately delayed your thing, or that delay was on the basis of sudden reasons german to the issue. That is why only we are examining.
If that be so, my lord, my humble contention, my lord, if I may be allowed to make.
Why do you think I'll not
Subject
allow
to-
you to make?
My lord.
Why
Sub-
this presumption?
My lord,
Huh.
on previous occasions, my lord, your lordship had expressed a possibility that in case if it is found, then there would be would be a question of even recovery. That was one observation that was made during the course of this proceedings.
No.
My humble contention would be,
We can't direct for recovery. We can direct the authorities to have an inquiry for recovery.
that is there. But my lord, my humble contention here would be, this respondent number 9, he eventually, no harassment, he eventually got the funds. He utilized it. He completed, I have my facts. He
We accept
eventually
that.
completed his.
That is not disputed.
He eventually completed his PhD as well. He left the university and he is settled somewhere doing a job. Now, the only anxiety that respondent number 9 is having is on that aspect of recovery, if at all, if this falls from this honorable court.
So don't worry. This court, in this proceeding, will not issue a mandamus directing for recovery. It may, if it comes to the final conclusion, that the projection as made by you, which led to the service prejudice being caused to the service of the petitioner, then we may direct the university and the Inspire authorities to take appropriate
And
action.
otherwise, my lord, eventually the grievance of the petitioner, so far the decision of EC is concerned. To that effect also, at this moment, it is almost,
It all boils down to you.
it is redundant for the respondent number 9. For as of,
The whole proceeding before this court today has the roots
I understand, my lord.
in the actions of the respondent number 9.
True, my lord. But
In
then,
approaching the university authorities with 3 names of professors,
my lord,
nomination as the supervisor,
My lord.
even before an application for IPP was made. You seem to be very popular because you are a very meritorious student,
perhaps.
maybe a
the-
darling of all the teachers.
Perhaps sympathized also
But
university.
that action
My lord.
has resulted in a teacher being put to suffering.
My lord, that suffering perhaps is also not something that he has been required to face. Why I say so, my lord? Because eventually the decision of the EC was stayed by this honorable court way back in 2018.
It
He was-
stayed.
It was
It
stayed.
stayed. It is stayed.
It can be set aside also.
No, it can be revived also.
It- my-
It can be revived also.
My lord,
So
on
we'll
all
have to
this,
be very careful.
my lord, on all these 3 counts, respondent
Okay.
number
Yes,
9
Mr. Doctor, anything more?
My lord, two small submission.
Because you are the catalyst
Yes,
between the problem and the
Yes,
cause and the effect.
I'll show, well, I'm not the catalyst in fact.
Hmm.
Well, in fact, well, there is no allegation that I'm in any way responsible for his harassment. Well, there is no-
Well, tell me one thing, only thing which I would like to.
Yes, ma'am.
Even before he took an IPP admission,
Yes, ma'am.
why did you recommend that?
Exactly. Lordship will look at into well, page 48 and 50 together. This
40?
Annexure 6 and 7.
Of the writ petition?
Petition. Well, these two documents have to be read together.
Huh,
This cannot be
clarify that.
read in isolation. Well. Lordship will see what these documents are all about. Annexure 6 is at page 48, my lord.
49, you come to the original.
Yes, I'll come to the original, my lord. Well, this is, my lord, letter to the register requesting to sign an endorsement form. This is basically a forwarding letter, nothing more than that, my lord. With due respect, I want to inform that I am Dibendu Shaha, an IPP student of the Department of Mathematics of the university. So he's saying, Lord, he's an IPP student, my lord. And I have applied for Inspire Fellowship for pursuing the doctoral program, and therefore I am in need of an endorsement form signed by you. Hence, I request to kindly send the endorsement attached. Endorsement form attached. Also, I am attaching the supporting document herewith. So, my lord, this is a document which has been signed by the petitioner, my lord. Now, my lord, he forward, my case is that he forwards this to me, my lord, that has not been disputed. Now, this has been forwarded, my lord. Where, my lord, lordship will kindly page to page 51. This is not a my lord, letter written by me, my lord, or a document written by me, my lord. It's a format in which, my lord, just filled up. The blanks are filled up, my lord, and I signed as a signature research.
No, that's what I'm saying.
Exactly, my lord.
The petitioner,
Exactly, my lord.
he forwards it that
Exactly.
saying that he's a IPP program student.
Exactly, my lord.
And
Now,
when
my
it
lord-
comes to page 51,
Yes,
it becomes a doctor.
exactly, my lord. Now the issue here is, my lord, if the understanding was not that he was not eligible at that point of time, my lord, why did he forward it?
He
That's the
forwarded with
question.
the understanding, my lord, that this, perhaps this is a mistake, bona fide mistake on part of him.
Okay,
also, my lord.
come to page 53.
Yes, my lord. 53.
Hmm.
Yes, my lord.
It says, so and so has been pursuing, awarded so and so, I am pursuing PhD under the supervision of Sanjeev Dev Sengupta.
Yes,
You could not have come in at this stage.
because, my lord, I
You
am
will come in after the departmental
exactly. No, my lord.
committee.
There, my lord, I am relying upon another document, though this has been disputed. This is one document which I am relying upon in my affidavit, my lord. True, my lord. That is disputed, but this is at page 21, my lord.
No, disputed by you.
No, by them. By the petitioner.
This one,
Page 21, my lord.
page 21 of
21
your
of
affidavit.
my affidavit. My lord, there was an arrangement made, my lord. Of course, my lord, he's saying that this is not there, my lord. This was an arrangement made, my lord. Where, my lord? Some departments where some people were allotted, my lord.
Were you allotted to?
Yes, my lord. SSG, my lord, this Sanjeev Sengupta, Dibendu Shaha, my lord. Where my, of course, his signature is not there. The petitioner's signature is not there.
Where?
Dibendu, my lord, page 21, serial number 1, my lord. Dibendu
Running
Shah.
page.
Running page will be, my lord.
Your respondent number?
8, my lord. I'm sorry, the running page, of course. My lord,
Okay,
is
no need, we'll find you. Yes, page.
21, my lord. Dibendu Shaha, my lord. SSG, Sanjeev Sengupta. So some students were allotted to different departments, different persons. Well, this was, my lord, on 7. Some date is not very clear. 7/1/2016, I guess. My lord. That's the only copy he had, my lord, with him. He had retained.
Sanjeev Bhattacharjee. No.
Sanjeev Sengupta, my lord.
Sanjeev Sengupta.
SSG, my lord. That's in short form. It's written SSG, my lord. And he has signed it at bottom, my lord. His signature is also there. Page 21, the bottom, my lord. It's a photocopy of, my lord.
When did you file that affidavit?
That affidavit was filed, my lord. They will reply to that affidavit also. But there is none.
Sanjeev Sengupta. Yes,
Yes.
252. Yes.
Yes.
Page 21.
21 internal page, my lord. This is the only thing he retained, my lord, at that point of
Okay,
time.
show me a date here.
Date will the bottom, my lord.
16.
16, my lord.
So
It's the 7/1/16, something like that, my lord. Now this is on 19/16.
this is 7/1/16.
16, my lord. And this is on 19/16, he signed this letter, my lord.
Okay.
51.
Okay.
So basically,
So,
my lord,
okay, I got it. Let us accept that.
my lord.
Test that.
Now,
But the person,
my lord,
this respondent number, Dibendu Shaha,
my lord,
admitted, let's see, that admission is PhD admission.
my lord.
On 11/1. Prior to that, how could this have been done?
No, this is on 16/1, my lord.
No, 7/1.
No, my lord. This is signed on, my lord. 19/1/16, my lord. Sanjeev Sengupta signed on 19/1/16, my lord. Not prior to that. That is 7/1. My lord, he said I joined the doctoral program on
See,
11/1.
down below, 7/1.
Which one, my lord?
Down below,
Which
page 21.
Yes, my lord, 7/1. Right.
7/1.
7/1.
And the admission is on 11/1.
Admission is in 11/1, my lord. But
So
then,
before admission,
like there were some arrangements made that it was understanding, my lord. But then even then, my lord, this is signed on 19/1. This is signed on 19/1, page 51.
we have a signature of 7/1 also, down below.
7/1 was that, my lord, that committee, my lord. Where, my lord, this-
Waiting list.
yes, my lord.
Then 7/1.
Page 21 is what you were referring to.
So before even admission, distribution is made.
Some distribution was made, my lord. I did not make the distribution, my lord. It was made, my lord.
Where is his signature?
Other people said,
Where is his signature?
his signature. That is the only page I retained, my lord. Even otherwise, my
How
lord.
can we give any credence to?
I understand that, my lord. That's why I'm saying, my lord, this letter, even
And this letter is not even relied upon by your authorities.
they have not relied upon. They have not relied upon. Because this is the only thing that my departmental committee, my lord. In any other ways, my lord.
This can be seen in a different light also.
My lord, I'll give it.
Because this never
my lord,
came up in the affidavit that was filed by
that
the,
was not there. That's not.
they
But
have
then-
not said that.
But then lordship will see this 48 and 50, my lord. I mean, in any case, my lord, there is no question of my lord misleading anyone, my lord. Because if it was signed by my lord, the petitioner later on, my lord, he had signed it as an IPP.
Say, Mr. Doctor, now the materials that are before me,
My lord,
he is a topper
my lord,
and you are his teacher.
my lord,
Naturally, you will have a close,
my lord,
he'll be very close to your heart.
my lord,
No mistake in that.
my lord,
But see, the actions that are there
My lord.
done, that has subsequently snowballed
my lord.
to an extent that his services have been.
Understand that, my lord.
To that extent only we are
I
concerned.
am not a part of that. my lord.
What you have done for him,
My lord,
because maybe you wanted a bright student like him
my
in
lord,
the university itself,
my lord.
to do the PhD in the university itself. You didn't want him to go out because he would have had other opportunities also. But now see that actions you have taken
My lord.
as,
My lord, first of all, my lord, my submission is that I am not a part of that, what happened subsequently. my lord.
No.
There is no allegation against
you are
me.
not there. You are only on
Yes,
this part. Your connection is only to consider whether 11-1 he is a PhD
Yes,
or not.
So, my lord, my humble submission is, my lord, when this particular 48 and 50 letters were signed, my lord, by both the petitioner as well as the respondent, private respondent, respondent number 8, my lord, that was, my lord, with the impression, my lord, I think both of them had the same impression, that, my lord, it is the IPP, because, my lord, subsequently also 2 letters were signed by the petitioner, my lord. I'll show that, my lord. Lordship will come to, my lord, then page, annexure, my lord, 9, page 53. Yeah, Lordship referred it, my lord. There also, my lord, both of them signed, my lord. My lord, Lordship will see at page 53, number 2, serial number 2, I undertake the following. The date of enrollment, registration of PhD program is 11-1-2016. Now, my lord, this is signed by, my lord, the petitioner, as a head of the department, my lord, and also, my lord, by the supervisor, my lord, that is the respondent number 8, my lord. That is in, my lord, 9/4/2016. Then again, my lord, Lordship will find page 55. Now here, Lordship will find this is again date of joining the fellowship scheme, 11/3/16. The date is given. It is signed on 10/12/2016. And, my lord, it is also signed by the, my lord, petitioner as the head of the department and the, my lord, private respondent, that is myself, my lord, as the supervisor. Then, my lord, again, page 57. 10/3/16 again, date of joining fellowship scheme. This is of 13/1/2017. The petitioner signs as the head of the department on 16/1/17. I also sign, my lord. So till then, my lord, both of everyone was under the impression, my lord, that it is the IPP which will be the, my lord, the date on which, my lord, admission to IPP is the date, my lord. And, my lord, thereafter, it is only, my lord, in page 58, my lord. Sorry, page 63, my lord. The same form, my lord, which the petitioner did not sign, my lord.
And
That-
that then led to the whole thing.
That led to it. So it was initially all of them under the impression, my lord, that this is the, my lord, thing. So it was perhaps a bona fide mistake on part of everyone, my lord. If at
Yes,
all
Mr.
it's a mistake, my lord.
Anything more?
Yes, slightly. I think we have little bit deviated from the slight deviation.
Side? Deviation.
Deviation. You.
Ah,
Please take the order of detail 12/2/24.
12 of this code.
Yes, last order. There are 3 issues.
12
by
two.
Lorships. Yes. 12/2/24.
Huh.
Does it got it?
Huh?
See the 1, 2, and 3. Question framed by your Lorships, my lord.
This has not been answered, unfortunately.
Yes. See the number 3.
I've
You got it?
I have noted.
Yes. Now, by the affidavit filed by Melandis and the university, in para 3(2), this say admission into IPP is admission into PhD.
He has read that to me.
That's what he has said.
And you have seen my response also.
Yes.
Then,
I want to add sugar to that.
okay, you're permitted. Don't add salt.
Please come to the affidavit of the university. First affidavit filed on initial, my lord, 8, 10, 18.
Okay. Page, para.
Paragraph, page 5, para 19 and 20. Just 2 paragraphs. Para 5. With regard to the status of paragraph 30 of the writ petition, deponent begs to state that respondent number 9 took admission into PhD program as per Assam University ordinance on the Doctor of Philosophy under section 28(1). That page 37. Next paragraph. That with regard to the statements made in page 33 of the writ petition, deponent begs to state that respondent number got his fellowship, guidelines, following guidelines department, inspire guidelines, page 38. Now, another one. See my reply, number 3.
To that affidavit,
No, my reply to the affidavit.
the latest
This
one
one, no,
or the
no.
earlier one?
It was filed on 27/11/18. Third,
Against whom?
against this particular affidavit, the one just now I read.
Okay.
Page 20. Dark color. Next page 21.
Yes.
This is prospect of the university. What does it say? Please come to page 21 in the middle. Candidates securing 55% marks in each paper separately in the integrated pre-PhD coursework exam are eligible for provisional registration PhD per rules. So the ordinance, inspire fellowship guidelines, the prospectus on which the university relies and filed the affidavit. Yes. And now in paragraph 3(2),
They have gone totally.
because now they cannot say it by not because of Mahinder Singh Gill. He's looking at us. And this is the judgment. Paragraph 8.
Why go to Mahinder Singh Gill when in the affidavit itself, before
No,
this court, they have
No,
said
that's
that
sugar. I
it's
said
ordinance.
sugar. That's sugar.
That's why I asked him.
Yes, my lord.
First time when he made that submission.
Yes, my lord. So,
And just one more thing I just would like to add, Madam. The allegation that I signed it first, I have said, I have denied it. Madam. He has not replied in saying, Madam, that that allegation is not.
Mr. Doctor, you are here not for an allegation against you. You are here for being a participant.
No, my
You
lord.
know, being a part
My lord.
of that
No, because
necklace,
Madam,
which is now in his
no,
neck.
Madam, there is a prayer that the departmental action should be taken against me. That's the reason.
That's on that context. In that,
That's my lord.
My
That's why,
lord,
my lord, I'm
I
on.
just miss one thing. My last affidavit filed legal study, it's there with the lordship, my lord.
it's a,
Yes, just. Yes. Filed on 22nd of.
I have it.
Please come to page number 379. Annexure A, my lord.
Yeah.
See the procedure followed. Same procedure. IPP, 55 marks. Lordship has seen notice of 2013. The university follows this. Eligibility criteria. Kindly see middle. Secure 50% marks. PhD program. Everything same. There's no change in it.
They read that nicely. Eligibility criteria.
Candidates seeking marks or above of examination are only eligible to apply for admission one semester.
One semester integrated PhD program for so and so, so and so, so and so.
Yes.
So and
that's
so,
what-
so and so, so and so.
Yes. Yes.
Work with explicitly full for so and so. Once you qualify that, one semester having one paper and obtaining 55% can also apply for provisional registration to PhD program directly.
Direct.
So if you have done that somewhere else,
Yes. Now my purpose of saying
you
is.
bring that then only
No,
direct.
my purpose of saying is, see the procedure followed earlier, that one, 3 consecutive ordinance, then inspire fellowship guidelines, the prospectus. and
No,
now the
that's why
candidate- that's what-
I was
that's what I
telling,
meant.
I was
Yes.
telling Mr. Chakraborty also that 1 year, 2009, that prescription, university is following, but in 2 compartments.
Yes,
And that is very explicitly clear from the advertisement and this also.
yes,
So now we'll examine.
yes, my lord. Only one thing, my lordship is the other day asked us to make a written argument on my lord. I just make the written argument.
Okay.
Along with the page marks so that it became easier for you, my lord. Argument.
Oblige, Your Lordship.
At last, my lord, I'm sorry, it is finished today. It took a very long time.
That copy of the affidavit may keep.
Just find it out if it is there. But I think I've seen it,
Then it doesn't.
whether from you or from here, I don't know.
It doesn't. Yeah. No, I'm not doing it. And the second part will be my lord. First is the gist, and my written submission is the
No,
page
I've
number
seen
8.
it.
Page number 8, my
I've
lord.
seen it.
And submissions, my lord. And so obliged, my lord, such a patient hearing lordship is given all these days, my lord, not only today, my lord. Obliged.
Mm. List this matter again on 14/5/2024 for delivery of orders. 14/5 delivery of orders. In the billing now.
My apologies, my lord, I could not get the instructions. Will your lordship accommodate me for a few days, my lord?
My lord, can I place one document, my lord?
Yeah, yeah.
Yes. Here the admitted position is, the petitioner is,
Litigation, business matter on 14.
petitioner was promoted from grade 7 to 8. What his promotion order speaks, my lord, that's.
I think it's
your
on
lordship,
here.
very-
I think it is on record.
Subsequent one. Security officer.
No, not there, not security officer. This is the promotion from grade 7 to grade 8.
I think there is something on record to that.
No,
It is 97, I think.
It will. Well, it will.
It is there.
It is
Page
there on
98,
record.
my lord.
And my lord, this is the, your lordship kindly read the,
My lord, I
it
have
says
some-
he was promoted from grade 7 as operator to a grade 8 as operator. Now the question comes, whether operator post in the
Single cadre.
single grade.
That
But
is all.
that
I
is
have,
not
my
a
lord, I have
single
some
grade.
specific instructions on as regards this. Because if this is correct, my lord, then
Then he
this,
should not have-
my stand will go, my lord. Because what happens, my lord, sometimes there is redesignation of posts also.
No, that redesignation cannot be to his prejudice after he is brought to that cadre.
No. There, and another thing is, my lord, I have also sought specific instructions. There is a merger of cadres. So lordship, can it be fixed next week, my lord?
We are also not in a rush. Where was that in the
No, because if this is correct, page 98.
No. These orders were there on record.
Yes,
Where,
yes,
where
it is.
did you find it?
It is page 98, my lord.
Ah,
Yes, 98, page 98.
97, 98. But it's
97.
an affidavit and reply filed by the petitioner.
It is there, my lord. I have sought specific
No,
instructions.
this is,
And if it is there, my lord, I
I think
will,
we have gone through this yesterday.
Yes.
That day, last day.
as a counsel, my lord, I will not come in the way. If
No,
he is-
no,
he is
not that,
entitled to
because
some
I have
relief, my
not-
lord. I'll place the facts.
We know Mr. Deca. So you need not have any apprehension on that.
My lord.
My lord, only thing the petitioner is still in service, my lord. He has
No.
not retired.
Retired করলেন নি?
As far as we are concerned, tentative view till date is you are entitled, you were deprived. Subject to Mr. Deca
Just-
clarifying.
My lord, my lord.
Because we don't feel that 4A and 2D.
Hmm.
2D, 4A is basically a clarification. Till now, that is the view I am taking. On the prayer of Mr. N. Deca, list this matter again on when?
1st of May, my lord. Next Thursday.
First of board revision.
No holiday. Second, my lord, second will be.
Huh?
Second is a Thursday. Second of
18, 40, 58. 58 Manovo. Did it? 1-5.
My lord.
1-5.
15, 1-5.
1-5.
It's a Wednesday, my lord.
When, no problem.
I'm like,
Because I have this top of the list matter, so it will come. Top of the list. As a top of the list. matter. Iman?
May I please, lord, sir?
Okay, that matter wherein whether after time, that's the case, I suppose.
Yes, no, the only question after the remand order by the division bench was that whether the retirement benefits.
Huh.
The gratuity we have paid, Malo,
Huh.
gratuity entire payment. Now,
Mr. Ganguly, when this matter, I went through the first instance,
Lordship,
going by the normal presumption we have with regard to a 309 rule.
Lordship,
So the bank regulation would be of that level,
Lordship.
if not a 309. So I was under the impression, how could an agreement go beyond that? When I examined the matter, just making my query clear,
Lordship.
I found that this basically is an agreement under 18
Lordship.
ID Act
Lordship.
between the management
Yes,
and
yes, that is a crucial difference. That is a crucial difference.
that. So if that be so,
Lordship.
that can supplement even the
Here I would just like to point out one thing. Bipartite settlement referred to in escape pool judgment, which they are relying upon. that is for the benefit, my lords, of the workmen.
That's what our next
And
question
here
would
he
be.
is a-
Whether that SK Cool's judgment
Lordship,
and the prescription as made therein
Lordship.
would be applicable to the petitioner herein because he may not be a workman.
No, it would not. I have a judgment of the Madras High Court which inter alia says that SK Cool, which specifically.
Workman.
Yes.
Show me. He's not a workman. What is he now?
He retired as a branch manager.
No. When the issue was being done, he's a branch manager.
Yes.
So he's not a workman.
No, he's not a workman. So SK Cool will not apply, my lord. The bipartite settlement is only between the
Do you have a
banks.
copy of that bipartite settlement somewhere?
Bipartite settlement I have filed, my lord, in the record of the appeal, my lord, in the writ appeal. Lordship has the
record asini here.
WA 313 of 19. Writ appeal.
I don't think so. That is here. Asini na it's like it will not be.
I had placed by an affidavit because this precise question, my lord, was raised before the division bench. Division bench did not go into this aspect. Division bench
Because we
only-
may have to go into that.
Yes, lordship will have to go there, surely,
We'll have to go.
surely.
Cool, SK Cool, whether it is limited to, I just wanted, means I had it. I had taken it out.
Yes.
I felt
In
it
fact,
was
even
so
after-
interesting.
Even after SK Cool also, my lord.
No, I went, I was scrolling through the matter in the net
Lordship.
and I got that agreement on the last date.
Yes.
But yesterday I forgot to go back to that because my notes were ready for this, so I did not apply my mind.
What I may, if I may suggest.
Yes, you are appearing for?
Lordship, actually, I am appearing for acts on the matter. Amar Sorbudikari has been suffering from.
More can bear is a kuna nai.
Lordship,
Time sound commission.
may I please, Lordship?
Full dias, na? More can bear is Yes.
Lordship, Angus Council, Amar Sorbudikari has been suffering second pox. So actually, I am appearing for.
Can you be a little bit louder? I don't know whether it's me losing the power or the sound something. Can you be a little bit louder?
Lordship, Amar Sorbudikari, Angus Council, he is from Calcutta. He has been suffering from second pox and medical certificate is here. So,
Can't help it.
Lordship.
When?
So next week of the May.
Mr. Ganguly,
Lordship.
interesting question. We would
Yes.
like to examine this.
So what I'll do is, if I may say so, I'll annex the copy of the bipartite settlement, SK Cool, subsequent judgments, everything, my lord, I'll present in a compilation. That will be.
That would be great.
Lordship.
That would be great. When?
Let it be in the second week of May. First week, I think, lordships are.
We'll keep it part.
Lordship.
It is submitted at the bar that the learned arguing counsel for the petitioner is suffering from, is under medical attention, and accordingly a prayer for adjournment has been made. List this matter again. Prayer accepted. List this matter again. On when?
Lords,
13. Lucky day. Okay.
13.
Mr. Ganguly, any problem on
No,
13?
no difficulty.
13/5/2024 as a part of matter.
I'm like-
Ito, by slip. And also, just for the understanding of this court, one issue troubling me. Whether the bipartite settlement adds to the list of the penalties already there under the regulations of the bank, or it substitutes one. Say, let's say SK Cool is applied here.
Lordship.
Two, does the bank have the power
Lordship.
that say there is a penalty? Because in Cool, you will find the penalty is removal with pension.
Yes.
Now, in a given situation, I've been trying to find out a judgment, I've not been able to.
Lordship.
The bank decides because of the gravity of the offense
Lordship.
that only removal. Whether the other part will automatically attach.
Lordship.
Just,
I understand.
just try to address this issue.
I'll try to.
Just try to address that.
Lovely.
Yes, Mr. Chaudhary.
Right, Your Lordship. One of these three matters are identical in nature.
Hmm.
The issue here is, they have challenged the denial of their LGC scale of pay on the ground that they don't have net slates. Although, my lord, there are notifications which say that, my lord, the exemptions have been, my lord, exceptions have been created and they are entitled.
is this your case that under that UGC notice, MPhil within 2009
Yes.
will be exempted?
Exactly.
You're on a wrong court. I think I have decided this issue. I said that is not applicable. Shaha. Huh? Om Prakash Shaha. I don't know whether right, wrong, but we have given something there. If I remember, Om Prakash Shaha. I think you will have to examine that.
Let me go through that judgment.
I don't know. If that is the issue,
Yes, that is.
say you and the university system,
Yes.
and you were provincialized. You took in terms of that government of Assam notification also,
Yes.
as well as the notice
Yes.
of the government of India.
Yes.
You proceeded to have that MPhil before 2009 or
2009.
something. That notice regulation, that the notice of the UGC was considered by the central government. Central government refused to endorse that. So that died its natural death. Subsequently, the government of Assam had also withdrawn. You're here.
Yes.
Second off, I'll try to have that judgment. 2 o'clock we'll have this matter. If not otherwise inconvenient.
I can provide the number.
I think I have, or you can provide the
Yes.
number
If
so that he
you
can
get the
just go
number,
through it.
I can get a copy of the.
Just give him the number. Mr. Shoma,
Yes,
have it.
Yes, sir.
So, Mr. Just go through that. If that is the issue, I think you will have to make arguments beyond that. We'll have it at 2.
Wait, please, Your Worship.
When did you retire?
Worship 2018,
18.
October.
What is your prayer here?
Where is my provincialization, Worship?
Under 2013. You went up to the division bench.
Yes.
What happened? Did the division bench permit that?
Division man said that
Where is that order?
The order is at page 32, Lordship. 32.
So when the division bench in 2018 said this, right?
Yes.
It did not allow you under 2011.
Yes.
It said consider under 2017. 2017 earliest consideration is 1/1/2021. You are not eligible. You retired in 2018.
Yes.
The act was not applied prior to 1. Am I right, Mr. Sharma?
Yes, Nanda.
1/1/21.
Yes.
I has been left out in 2014. What?
That is gone.
Yes.
2011 Act, whatever was done, not done to you, that is gone. So direction here is 2018, 2017 Act, right?
Yes.
And you withdrew the writ appeal
Yes.
with the direction that your case under the 2017 Act will be considered. Even if it is considered, no benefit can be given to you because the benefits under that Act was given from 1/1/2021, not prior thereto. Yes, Mr. Counsel, how can we help you? Maybe this is something which has just come to your notice, right? You examine, come back at 2. You examine, read. Break your head, get something. 2 o'clock. Examine that issue.
What's it next week?
Examine. Any other work now? Going home.
Not going home.
You're here only? Go and read. Come back at 2. Tell me. I have told you something.
Yes.
It may be wrong also. That is a view. Dispel that. Read the Act. Act of 2017. And then come back and tell me if you have a case. Then we will examine. Right? if you find it difficult, we will accommodate, but you do your work first.
What's it, can it be?
1, 2, 3 hours
What's it, can it be tomorrow also?
tomorrow.
Tomorrow.
Okay. Kali. Wisely. Wisely, tomorrow.
Obliged.
But work on this.
Yes, yes.
Get me something. On the prayer, on the prayer of the petitioner, list this matter again. Tomorrow if you want to take over. Process
26.
26. 26, 4, 2024. Oh. Oh.
Okay.
May please your lordship.
Hmm.
My lord, our affidavit is ready, my lord. Today we'll send it for vetting, my lord.
You are appearing for?
Big away, my lord. He's on legs, my lord.
No, you are appearing for whom? Which-
SSA, my lord. Servicing officer.
Okay. It is submitted on behalf of the London Standing Council, SSA, that the affidavit on behalf of the said authorities is ready and would be filed.
Short date may be given, my lord.
That's what. You give me a date. Your affidavit is ready.
Ready, my
So
lord.
tell me when you will file it.
Next week, my lord. Next week, my lord.
Would be filed by 30. Would be filed by 3/5/2024.
My lord.
So accordingly, list this man. Also, the petitioner is at liberty to file a rejoinder thereto. Also, list this matter again on 15/5/2024.
Obliged.
15.
Highly obliged, my lord.
Your lordship, may be taken at 2 PM, lordship.
Why?
My senior is not available right now.
Where did he go?
He is on the way, lordship. He's not available in the court, lordship.
I think I heard this matter the other day. Okay, that matter. There is another case connected to this.
18.
17, 18 ekal case. 2 PM.
Yes, lost.
Any development? Mr.
Yes, Lordship.
We'll have it. You be relaxed.
Yes, that with my colleague leadership program that right there.
You
The secretary has approved it and he sent it to the finance department for his approval.
fine. That
And
is enough.
thereafter, Lordship will get it.
Okay.
Yes.
Just we'll have it after.
Yes.
Whenever you have it, just tell him.
Yes.
Yes, madam.
My lord, petitioner is by a notification dated 31/3, petitioner is appointed as a managing president.
You were supposed to address me on the maintainability.
My lord,
So tell me, what is your legal right that has been violated?
petitioner legal rights is that my lord, he was removed, my lord,
Have you prepared on that lines?
my lord.
Have you prepared the matter in the line I asked you?
Yes, my lord.
Have you got judgments?
Judgment is not.
No,
I don't.
I'll not hear you. I want full preparation, full judgment, full everything. You will have to satisfy this court that these are the judgments. You have to pass an order in my favor. Then only I'll hear this matter.
My lord, sometimes may be given, my lord, next week. my
Sometime, how many time? 1 hour, 2 hour, 3 hour? How many?
No, my lord,
Day.
next week, my lord.
You tell me a date. As per your date, I'll fix. But this time, don't come with empty hands. I want your cities of judgments. You'll get it. Just little bit of work. You'll get it. When?
13 of May, my lord.
Huh?
Second week of May, my lord.
2nd week of May. Yeah, okay. Okay. On the prayer of Miss L. Wajida,
My lord.
Learned Counsel for the petitioner, who seeks an accommodation of the matter in the matter today to prepare the matter for addressing this court with regard to the issue of maintainability raised by the respondents herein. Full stop. prayer allowed, list this matter again on 13/5/2024 for further hearing. I will want full, not like this, just get a file, whatever is written, they argue, that is not your age. Right? Full-fledged argument I want. And I'll give you time for that. And don't bring any senior. I'll not hear. If the matter comes to this court, we'll hear you only. What is the issue?
Challenging the termination order, my lord.
Just a moment. Item number given?
My lord, page number 61.
Okay, that 20 years, huh? How can you dismiss his terminative services from 2001? No, you may be permissible. It may be permissible. I'm not saying it's, show me the law. So I also can update myself.
I will take instruction.
You were supposed to on the last date.
No, my lord.
Last date, this was the place where we stopped. And you or somebody who was there. Yes, Mr. Sainik, that was the place we stopped.
My lord. Well, at this station, notice may go, I'll bring.
Tomorrow हो गया सर. Okay, how are you entitled? Rightly so. Now I remember why this matter was postponed. We did not want to dismiss this matter before Eid and Bihu.
Yes.
Right? Yes. Show me the order of this court. When that order is sustaining, how can I go beyond that?
But the direction was from this
No,
court, my lord,
the direction was very specific.
to adjust the petitioner against, my lord, non-plan vacant post, my lord.
You come to page 58.
Yes, my lord. Paragraph 11, my lord.
For the reasons discussed above, there is petition is directing them to adjust the service against so and release the salary for the period already service already rendered by him from 26/3 to 21/1.
Yes.
So that much they'll give you.
Other direction to adjust the petitioner against non-plan.
Where is that other direction?
My lord, the dispose of directing the respondent authorities to adjust the petitioner against any vacant post.
No, this adjustment is only for that salary, for that period.
No, my lord, it doesn't say so, my lord. Perhaps, my lord. For payment of the salary, my lord, they can create a supernumerary post also, my lord.
Against any vacant post, read the earlier paragraph 10. Against any vacant post for the purpose of payment of salary as indicated in the order dated so and so, should not have any difficulty in adjusting the petitioner against any vacant post and to pay his salary for the period of the service already rendered by him. It does not say that for your continuance after 2001, because it does not deal with that. This order was passed.
No, my lord, that is true, my lord. That aspect, my
This
lord,
order was passed on 2020.
that is true, my lord.
So when it is 2020, from 2022 to 1/20/2002, till that day at least,
Yes, sir.
this court is silent. How can we now go and add something there? So rightly so, they have terminated your services from 21/1/21.
The direction was to adjust the petitioner against permanent enforcement.
Huh?
Direction was to adjust the petitioner against permanent.
Maybe until and unless this order survives, we can't go beyond this. You will have to file a review to this. Withdraw this, file a review, we'll give you liberty. Heard Mr. Ayat Sekia Lanet, counsel for the petitioner, and also Mr. P. Bora Lanet, standing counsel, elementary education department. Mr. P. Bora Lanet, counsel for the respondents has submitted. I'll put it in his mouth. Mr. Sekia, I'll put it in his mouth. As Mr. Bora has submitted that the services of the petitioner was terminated with effect from 2001 in view of the directions as passed by this court wide order dated 6/1/2020 in writ petition number WPC 488/2019, wherein this court had directed for the adjustment of the petitioner against any vacant non-planned vacant post for release of his salary for the period only from 26/3/1999 to 21/1/2001. Also, on consideration of the on perusal of the said order dated 6/1/2020, it is seen that the directions as passed therein is limited to the purpose of release of salaries with effect from salaries to the petitioner with effect from 26/3/1999 to 21/1/2001. Also, Mr. Ayat Sekia, learned counsel for the petitioner, has, however, disputed the above position and has contended that the prayer in the writ petition was for adjustment against a regular sanction vacant post. However, he also admits, in view of the order passed, in view of the directions as passed by this court-wide order dated 6/1/2022, the said prayer of the petitioner, although was held by the petitioner to have been granted, seems to have been ignored. Also, accordingly, he prays for liberty to withdraw the present writ petition to file an appropriate application seeking review of the order dated 6/1/2020. Also, given the facts as existing in the matter, also, as well as the relief that was sought for by this court, from this court by the writ petitioner in the earlier round of litigation, this writ application is permitted to be withdrawn with liberty reserved to the petitioner to file an appropriate application seeking review of the said order dated 6/1/2020. Accordingly, the present writ petition stands dismissed on withdrawal with the liberty as prayed for. I think you will have to get a clarification.
Wait, please, Lord. Also, this matter.
Yes.
Yes. Worship, this matter pertains to vacating the stay which has been given by the order dated 2026 to 2024. Lordship prior heard this matter and Lordship was of the view that it cannot sustain.
I think we wanted to hear we will hear the whole writ petition. You are for the vacating, you are for the applicant. Yes, Mr. Deka, you start off.
We are agreed by the order dated 29/9/2023.
Yes.
Your Lordship, the petitioners agree by the order dated 29/9/2023. Your Lordship will find at Annexure 9, page 32. Our contention is that, Lordship, in view of the two office memorandum of 2016 and 2021, without receiving the proposal from the school concerned, as well as the inspector of schools,
the recommendation has been made. Because we have to read the two office memorandum conjointly, and the office memorandum clearly says that proposal should be routed initially from the school concerned, and thereafter the inspector of schools forwarded to the concerned deputy
Okay, come
commissioner.
to page 32.
Yes, 32, Lordship.
32,
Erection
school is Ram Salapathar Sahed Ali High School.
Yes, Lordship.
And the private respondent is,
Lordship Hafizur Rahman,
and you are,
and I'm Abul Kalam.
both are under challenge.
Yes, Lordship.
Okay, there was an earlier round of litigation.
Yes.
That is at page 23.
Yes, yes. And
Okay.
in fact, Lordship, the contention of the earlier round of litigation also was that without receiving
Forget that.
Lord,
Earlier round of litigation, you were one of the petitioners.
There.
No.
Respondents.
Respondent, sorry.
Respondent.
Sorry.
Then ultimately,
You are respondent's number?
respondent number five and six.
5 and 6.
So matter was remanded, Lordship, to follow.
Abu Zafar Siddiqui
Yes,
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 and Nazrul Islam.
yes.
Hmm.
And matter was ultimately remanded back to the authority, and after the matter should be considered in view of the two office memorandum, and while considering, our case may also be considered.
Fine.
But that was not done.
No,
So
it's
this
me.
time also.
Me.
This time,
Shall, not shall, may.
yes, Lord.
And now what happened? Tell me.
Now, this time also, Lordship, without receiving the proposal from the school authority, the respondent of 5 and 6, they have been recommended. The Lordship, will kindly see the order that already the state respondents were directed on 2 occasions to receive. the
No, I don't
instruction.
want, but we forget that.
So ultimately, they have.
So your case is that in following the 2016
Yes.
and the 2021
Yes,
notification,
yes, Lord.
basically 2016 notification, his name was not recommended by the school authority.
Proposal not forwarded from the school authority, which is the.
It was there
mandate.
either in the deputy commissioner level or in the guardian ministers. Yes, what is your case?
And already
I-
this issue was already
This is
decided.
what has happened. And to be fair of this court, the procedure which has also have been taken, that was not done.
So we'll set it aside. We'll ask them to do it afresh.
Yes, okay.
Lordship, already this issue have decided, your Lordship, may I please the order.
Oh, that matter.
Yes, Lordship. Same contention, Lordship.
Okay, dispose of it.
That if do not, I may be set aside.
Fresh election will be.
But this time we are not going to repeat that sentence, may consider. We are not going to do that. College school authorities, whoever they want, they will do it.
By following the.
Neither you have any legal right, nor he has any legal right.
By following the two office.
Two office member.
Lord.
He seems to be very confident.
Yes, Lordship.
You also go and increase your PR there.
Yes, Your Lordship. Please, Your Lordship.
Deplorable. Oblige, Lordship.
Lordship, the engaging counsel, Mr. H.K. Das is appearing in court number 2, my lord. That may be possible for pending, my lord. Just-
Oh, that.
call for
Affidavit to affidavit. Yada kumari. Try in the second half.
Lordship, while preparing the case regarding Sainik school is a state or not, I got a judgment of Honorable Supreme Court in 89. It says that it is a state within Article 12.
That's all.
But that judgment was not taken into consideration.
No, we'll take into consideration because why I'm saying so. I had appeared for the army school authorities. So at that time, I made some research way back. Sachidananda Singh's
Yes.
case. So there in one case, he was an advocate, senior advocate then, my Lord Justice Chaudhary's
Yes.
judgment. He argued the matter in one case. And therein he had brought on record everything.
But
Right from the initial stage, he has brought.
Yeah. But this judgment was probably
This was not.
not taken to.
But then the fact was that Army school is not a state.
Yeah, in
But
Prabhunath,
Sainik school we found, I also found somewhere, I think,
but this is the only judgment lordship I found
no,
yesterday.
no, no, there are judgments of the high courts. Somewhere I found,
Yes,
that-
some high courts is there,
high court is there, and therein I think there was a reference to maybe this, but I missed it out.
but lordship, this judgment was never taken into consideration in any of the
We'll
court.
know, thank you, we'll know. So it's a state basically.
Yes, lordship. Regarding other points, lordship, lordship, another thing, my learned friend filed an affidavit yesterday, copy was served. In that affidavit, he has made some allegations regarding that he was sent out from the.
I've seen,
But we have video recording of entire proceeding, lordship. We will not say allow, we can produce that.
is this not burden enough for this court that I'll have to also see the video recording now?
No, lordship, because they have made. specific-
Orally, that you make a. Mr. Cal has gone to the media. We are still in paper. We'll have it. Let's see. Now, I'm seeing. Yes, Mr. Surya.
My lord, this matter relates to provincialization of service, my lord. The petitioner before your lordship was the principal of South Salmora College, my lord. His service was not provincialized.
Principal.
Principal. The-
Yes, Mr. Das.
Yes, my lord.
What is your,
Mr. Gogoi will argument. We are ready.
where is it?
It said that my lord, the 55% mark was required for provincialization. But my lord, the state of Assam has
Hey, more clearly सुन रहा है जो बोल रहे हैं clearly है ना?
has a
অলপ দেখাই ল'ব সাউন্ডটো কি হৈছে সাউন্ডটো কি হৈছে অলপ দেখাই ল'ব
It says that my lord, the 55% mark is required for provincialization. But there is a notification of the government of Assam relaxing the.
that is for a particular set of people.
It doesn't say so, my lord. Perhaps.
Come to that notification.
Yes, my lord. That is at page 67 of the petition, my lord.
Original 68, no, 67.
67.
67, okay.
This is a translated copy, my lord. Actually, at that point of time, my lord, notifications were published in Assamese.
Okay, that's right. Literature 47.5,
Yes.
other subjects 50.
My lord, and it doesn't say that,
Mr. So yeah,
my lord.
I'll not take up this matter today. Too much pressure.
There is also loss in next paragraph. Lordship
got
may
it,
not
I
take
got
the
it.
matter, but next paragraph, lordship.
I know, I've seen it.
Next paragraph, lordship. Next paragraph, page 67, lordship. As per proposal of modification, lordship, then lordship. the
Effect from 1487.
Lordship. For the teachers who have working for at least, those are in the deficit granting system, lordship.
I got it. I got your
Lordship,
point.
lordship.
You will try to argue that this is only applicable to persons who were already brought within the
Lordship.
government purview
Lordship.
and they did not come.
Yes.
So the day they came, whatever the norms are there,
Yes.
that you will find. He will try to develop an argument
Yes.
saying that I am affiliated. I think that's what I told you last day,
Lordship.
that we are there and we have the UGC norms applied to us through the affiliating university. So I am in the university system.
Lordship. And my first argument is, lordship, as per section 3(4) of 2011 Act, lordship. Section 3, subsection 4 of 2011 Act. lordship.
That
This is my argument, lordship.
that you will have to have it on that day.
Lordship. This is my argument.
We'll have it next week,
Oblige, lordship.
30th.
Oblige, lordship.
By that time, they will also be a freed up bit.
Lordship.
Please take it. at least taken up copy, huh?
May I please, your lordship, in this case, I have received the instruction. Already in the year 2017, GPF account was allotted, my lord.
No?
In the year 2017, GPF account was allotted. GPF number was.
My lord, they have not informed the petitioner, my lord. Opening of GPF account, my lord.
Lordship, the petition has come in front of us.
Next page is lordship, GPF allotment. This prayer is for open GPF account, lordship.
And deposits are being made in that account?
Lordship.
CPF account deducted and deposited?
Lordship, deposit, lordship, we have opened the GPF account, lordship, but they have to deposit the amount, my lord.
Oh,
Principal,
oh, that's what, who is paying for defense? But your prayer is for opening of the
Yes,
GPF
yes,
account.
lordship,
That
that
has
is-
been opened.
yes, lordship, petition
We'll close it. They heard Mr. D.K. Roy, Learned Counsel for the petitioner. Also heard Mr. R.K. Talukdar, Learned Counsel, I.A. Roman and A.D. appearing for the respondent number 5. The present writ petition has been instituted by the petitioner hearing, praying for a direction upon the respondent authorities for opening a GPF account in his favor so as to enable him to receive regular pension and pensionary benefits on his retirement. The petitioner was appointed as a lecturer in English in Hugh College, while an order dated 25/8/1984. Also, the services of the petitioner was regularized with effect from 1/1/86. So it is the contention of the petitioner that in spite of being regularized in his services, his GPF account was not so closed. So this court had, while an order dated 3/4/2024 passed in the present proceedings, required the Mr. R.K. Talukdar, Learned Counsel, IA and AD to receive his instructions in the matter. So accordingly, Mr. Talukdar, Mr. R.K. Talukdar has placed before this court a communication received by him from the Office of the Principal Accountant General, bracketed A, and A, Roman and E, Assam, wherein it has been contended that the GPF account of the petitioner bearing number CED-7491 was already opened. Also, they said communication also has its enclosure a letter dated 4/8/2017 issued by the Office of the Accountant General, bracketed A and E, Assam, with regard to the allotment of GPF account number to the petitioner. Also, the GPF account number to the petitioner, 4/8/2017. So in view of the fact that the GPF account was already opened in respect of the petition and a number allotted thereto, so the prayer as made in the petition stands redressed, and there arises no further issue for adjudication in the matter. Accordingly, in the light of the disclosure as made by the Principal Accountant General, bracketed A and E in the communication dated 18/4/2024, the present writ petition stands closed. Mr. A.R. Tabildar, Learned Counsel, Standing Counsel, Higher Education, appears for the respondent number
1 and 2.
1 and 2. A copy of the communication dated 18/4/2024 along with its enclosure is kept on record and marked as X for the purpose of identification. Evening.
Wait, with your lordship. Yes, your lordship.
Lordship, if I may, before the senior counsel starts, I don't want to like take up the senior counsel or your time, Lordship. Lordship, can this item be taken up at 2? Because the counsel, arguing counsel, Mr. B. Gogoi, he's arguing a case in court number 1, assisting the Advocate General. If possible, can it be taken up at 2?
At 2.
At 2, if possible.
Hmm?
If possible, can it be taken up at 2?
All right.
But I don't know how long will it take because I have fixed up a few matters.
Lordship.
So that might take some time. And the AG has a matter. at-
Lordship, it's a
5.
like a surveillance worker matter, Lordship.
No, there is a matter
Oh,
at
Okay, Lordship.
5 of the AG he wanted to argue today.
Lordship.
So
Then, my lord, may I pray that it may be fixed on Friday?
Friday will not be possible.
Then, and
Tuesday.
any day
Tuesday.
at the convenience of your lordship.
No, I'm Friday I have a problem, Monday I have a problem. Tuesday kita ase.
Tuesday, that case, your lordship has fixed.
Huh? Oh, Tuesday is bondo. Notary ke kita ase. Good, you know.
My lord,
I have already fixed 18.
that I know, my lord.
And from the bench, how much comes, I don't know.
Yes.
This 18 is mine. I fixed. So
Only
more matters will come.
anxiety is that, my lord.
But I wanted to because the problem with me is that every day I have to read it.
Yes, your lordship remembers now.
I forget.
Oh,
I forget. I'll have to read the
my lord,
Let's see.
permission has been given to us to open.
We'll have it on second. Huh? Second. But
No,
whenever the matter is taken up, please be here.
Lordship. We will-
Or do one thing.
Lordship.
If you want to have a specific date, tell me. We'll have it as the first item. Don't worry.
Absolutely. Lordship.
First, it admission me.
Admission, my lord. My
First
lord,
item as the admission. First item we will
First
have.
item.
You give me a date when you can be here, when the matter is called. Right, Mr.
only my lord, my anxiety is that it should not be again take.
No, that's what I'm saying. I'm asking them to give me a date.
My lord,
We will take it up as the first item
my lord.
of the admission column. You give me a date.
Uh,
Otherwise, we'll not hear you. We'll hear him and then pass orders. Tell me.
Second, Lordship.
Second,
Second.
Mr.
M. Bhuya, Lordship.
M. Bhuya, Learned Counsel appearing on behalf of Mr. B. Gogoi, has submitted that the matter be taken up on Tuesday. That is 2/5/2024. And it is assured that the Learned Counsel for the Health and Family Welfare Department would be appearing in the matter when it is called up. Full stop. As full stop, the prayer is accepted. List this matter on 2/5/2021 as the first matter in the admission column.
Much obliged.
Obliged, my lord. Only one thing, my lord. If we are not getting, they have permitted us to open the colleges, admitted 160 boys. They have finished their curriculum. Without affiliation, they cannot sit in the examination. That is the only thing, my lord.
Let's see.
My lord.
Much obliged.
IA pass. IA pass.
I have not studied anything in this case, I'm telling you. Last order. Where is the order?
Mr. Monto,
Hello.
non-technical results declared,
Yes, result declared.
appointment, the appointments not made.
Appointment to government, I don't know.
Non-technical already.
Yeah, this is the only
Already
non-tech-
passed an order.
Hmm.
Only remains the technical. part.
Technical.
I am actually not prepared
But if they are
Affidavit
urgently,
we have
I'll
already
do it, I'll do it, what to do?
No, no,
No, no. We have already filed our affidavit.
at least this
Affidavit
week.
file koriছে?
Well,
I can,
affidavit, yes.
Yeah.
We have already filed affidavit.
আমি reply দিছো না, reply দিছো আমি।
Nine.
If they have file affidavit, we have to give a reply then.
Affidavit I have filed.
Mr. Das, I have no problem in not hearing the matter.
No,
Convince Mr. Talk.
no, it's okay, my lord, this my age, I don't want.
We do, no, that's.
My age, I don't want, my lord, all this, I will do it.
No,
What
no,
is there,
wait,
my lord? It's
wait,
absolutely no
one day
problem for
we
me,
can
my-
accommodate Mr. Das. That is
No,
no
it's no problem. I understand my learned friend.
He
Dr.
has an
also
anxiety.
difficulties. I know, that's all
But
difficulties.
he
are
will
there.
also
I
understand.
also find sometimes I feel very embarrassing also.
Mr.
So I
Das, you
thought-
need not, you need
No,
not
I
feel
know, that's why
embarrassing.
I thought I can do it.
You
There's
need
no
not
problem.
feel embarrassed.
Uh,
For one day, we can
because
accommodate it.
My age, I don't want, my lord, all
You
this, my
will, you
lord.
will not have
This
it.
is only a client, I will go outside and forget, my lord.
You
That's all.
need
my
not,
lord.
at
Yes,
least
sir.
in this court,
Yes,
that
that's what
impression
I'm
you need
saying.
not have.
I was not aware also that some affidavit has.
Yes,
been
we have filed
I've been
on-
told.
Mr. Das,
Yes.
before this court, you need
Yes.
not have that.
But your lordship has said, for me also no problem, my lord.
You need not,
We are facing all these problems.
you
at
need not
home.
have that
Yes.
impression, at least before this court.
Yes.
I may pull your leg, that's a different.
No, that's but we accept all pulling of the legs. It's
Tell
there,
me,
my
when do you want it? Give me a
No,
date when you're free. We'll have one shot and we'll finish
Yes,
it off.
on 2nd or 3rd of May,
Second, no,
3rd,
the week next.
next what of my learned friend. I'm sorry for
On
my.
7, no, you need not be sorry.
Uh,
Because see, I am also having a problem today.
My
If I hear this matter,
Yes.
this matter I'll have to dictate.
Yes,
The 2 stenos only I have. And both of them are
yes.
awfully tied up. At least till Monday, Sunday, I can't disturb them. 7th,
7th?
7th,
7th.
8, my lord.
Eight.
Election.
Oh, 7th is election.
My lord, 8.
Then 9th. 8th is Wednesday.
No,
9th.
nine.
Any problems?
9.
9th.
No, for me, no
7th.
problem.
7th, your lordship, and we can come.
For me, no problem.
I'll
But
just-
I want a little accommodation some for the time being, maybe.
No, Mr. Das will start
No,
off.
no, no,
I'll
not
start.
today. When my lord, any date your lordship can fix, my
No,
lord.
he's
I
already-
No,
never.
we are having it on 9th.
My lord.
Mr. Das,
Hey,
when he
intermittent-
starts, he'll not finish in 10 minutes. Naturally, this matter.
Yes. I just want
He'll
a
take half
point.
an hour minimum.
My lord, I'll take 15 minutes.
I'll just give a reply in the meantime before in hand, so that he can look into it, not on the
All I
last
know.
time.
No
last-
problem. Yes. He has the
Not
right to
only
write the
last time, I
violation.
will pay.
Do you think
I-
Mr. Monto reads? He smells. He need not read. He can just see and.
Well, honestly, we want to finish it all this
Yes,
case.
yes.
Why? Because we don't want piling up of the cases in our home.
Correct.
I at least I don't want. Sometimes, yes, honestly, I'm telling you that sometimes there are cases
There are.
which we tell the court honestly. Even if the court wants to take it, we can do it because of my experience, I can do it.
But that
Maybe
is
I
not the
will
way.
not so thorough.
No,
Yes.
the thing is that will create problem for a novice like me because I'll not be able to applicate all the points.
Again, all the points, all experience you have.
Yes,
All the points.
yes, that is.
You don't have to say.
But still, when you argue,
No, this is a very.
I have a bad habit. I don't make notes.
I have seen.
No, I don't make notes. I keep on asking questions with a purpose. So whatever I require,
Then
it is recorded.
recording.
So when I dictate, I just put on that and I start dictating.
Again, go to the
Asking-
recording.
Your lordship, it's like interact. That's more better for us. We know where we stand. Interaction.
That's
That's very much required.
that is,
Interaction.
and I try to do it as far as
Yes.
possible because it helps me also
Yes.
to understand.
Interaction is that's why we know what your lordship wants, what is in the mind
It's
of the
correct.
court.
Next person is here, little bit delayed, but here.
He is also one of the minor respondent. No, nowadays.
We are suffering, your
The
lordship.
problem is this, minor clients are looking also minor.
No, that's I understand.
That is the problem, madam.
I told, I'm so sorry, I told my, the other side.
No, we'll have it.
Council
Let
also-
Mr. Das also be
Yes.
up to, so that it helps me also when I understand the points. On 9th, we will pick up this matter for admission as, for admission, no?
Admission.
Admission as the first item. Kar do.
Yes.
9th. The first item, itu kundina disu?
My lord, only one thing I'll.
ये वाला item कब दिया था? 2nd May, 9th as the first item in the admission column.
So final disposal. Final disposal.
Final disposal.
Final disposal on that day, my lord. Yes,
Final
this
disposal.
my lord will select.
Can you lordship keep it as parted minute?
Will not going to come before me. For will come before me. Don't worry.
Yes. April.
My lord, out of context.
Thank you.
My lord, out of context, another thing I want to say with your lordship. I think this is a high time, these glasses can be opened.
Mr. Doctor, today I was having a doubt whether I have lost my hearing. Then I asked everybody, are you hearing? They said no. Then I was okay. Two things are creating problems for me.
Yes.
One, this Berlin Wall should go. Secondly, the heat here is so much
Right.
that I have to on up, switch up my both the ACs. They find it problematic. They say they are going to Kashmir inside. But I can't stay. It'll go. A little bit of, maybe after, by next month, this should go because they have already placed, the people have not come. And this is high tech.
And we
I've
also
asked
feel,
the registry.
because of this, we feel very distance is too much.
Naturally, I feel it very uncomfortable.
Yes, yes.
I find it very uncomfortable, but can't help it.
My-
Apply.
Yes, Mr. Nath.
The matter is regarding, my lord, provincialization of service, the petitioner, my lord. Petitioner, my lord, earlier occasion.
You went before the education tribunal.
Yes, my lord. The education tribunal has rejected my prayer on the ground that your lordship will find it is page 53. Starts.
Who
from
is
page-
appearing for the private respondent? Mr. Bhia, you are appearing. Okay.
My lord, the amended writ petition has been served on us, my lord.
When?
We have not responded to yet, my lord, so.
Oh, there was an amendment.
My lord.
Amendment is there, my lord. Yes.
I think you will have to file a reply to that.
My lord, some.
He'll-
issues are there.
That,
Mr. A.R. Bhia, Learned Counsel, appearing for the private respondent number, for the respondent
My
number
lord,
7.
7, my lord. No.
Submits, 8.
Eight, my lord,
Submits that an amended application has been filed in the matter by the petitioner. Accordingly, he prays that he be given 2 weeks' time, 3 weeks' time
My
to
lord.
file an affidavit in opposition to the amended writ petition. Full stop. The learned, Mr. SMT Sisti, Learned Counsel, Standing Counsel, Department of School Education, also submits that the stand of the respondents be permitted to be brought on record with regard to the amended writ petition. Full stop. Accordingly, list this matter after 3 weeks. The respondents are at liberty to bring their respective stands on record by way of filing an affidavit in opposition in the matter.
lordship, earlier there was an interim order that in the earlier case that was disposed of, my lord. So in the meantime, the private respondent may not be, effect of provincialization may not be given, my lord. Otherwise, my lord, my whole exercise will be futile.
Why? Why? Tomorrow, Mr. Not be fined that you are entitled. We will ask him to go. And the only thing may be that this is under the 2011 Act. Right?
17.
So 1/1/2001, he is 21, he is receiving.
No, my lord, another thing is that they are standing that admittedly I am senior, but
No, let's come to that conclusion. There is no interim order here in this proceedings. So you're continuing, Mr. Bhia, you continue.
I am not continuing, my lord.
No, Mr. Bhia is continuing. Let him continue. We'll decide. Tomorrow we find that Mr. Bhia was not entitled. We'll ask him to go. We'll put you back. Then the question would be whether your effect will be from the date of your appointment or from 1/1/2.
Yes, my lord.
What I have done is, in 1 or 2 cases, I have put you back from 1/1/2021, but I have protected the pay already drawn.
That aspect.
So that will take care. So you did not worry about that.
Obliged.
Obliged, my lord.
May I please, your lordship? In this case,
Yes,
lordship,
Mr. Das.
we have challenged the selection process, lordship, whereby the private respondents are being appointed, your lordship.
Hmm.
And lordship, with due consideration, I would like to submit that there is certain anomalies while selecting the private respondents and in their appointments, lordship. So for that, lordship, if lordship is satisfied, may call for the records and the answers keys, your lordship.
Not before we hear the matter.
Lordship.
Affidavits have been filed.
Affidavits have been filed, your lordship. All pleadings
The
are-
affidavit by the state is on record and
And affidavit by the private parties also been filed. There are two writ petitions.
two writ petitions. In the second writ petition, I suppose the affidavit of the APSC has not filed an affidavit.
Lordship, in the second case, WPC number 4715, we have filed affidavit and that will
So that
provide
will cover.
cover. Lordship.
What is your stand?
So Lordship, they have the requisite qualification and experiences also, and there is no anomaly in the selection process. This is our question. And the point they have asked Lordship, that experience of the private
Subsequently, they
respondent
had given.
in a private institution.
Where is the advertisement?
Lordship, advertisement
is the first item.
We'll pick up the second item. That will be better.
Lordship is taking up the second item.
4715.
Page
You are there in that case also?
Yes, lordship.
Page 13, Lordship.
There is page number 13, your lordship. Advertisement.
That
Inspector of Schools, DEO, Deputy Director of under Assam Education Service,
Yes,
right?
Yes,
Lordship.
lordship.
And clause 3 Lordship, qualification.
Qualification.
Second class master degree having uniformly brilliant career with BT BEd degree and possessing teaching experience in school or colleges for 10 years or administrative experience of 10 years, of which 5 years must be teaching.
So where there is no prescription herein that it should be within in a government school.
Yes, yes. Even
Lordship,
that
there is no
Assam service
prescription,
education
lordship, but
rules.
what we are also.
What is there in the rules?
Yes,
Amongst the other grounds, lordship.
AES rules,
Lordship, Assam education service, page
page
713. 713.
698. Page 713.
713, that is 11, Lordship, schedule 1, Lordship. 3, Lordship. Schedule 2.
Okay.
Lordship, if I may,
Then, Mr. Das, what is the next point?
lordship, the other grounds in lordship is para 10 of the writ petition, lordship,
Para 10.
where there's been stated that the lordship, the
Just understanding the issue.
Yes, lordship. Para 10, lordship, in earlier litigation in 2013, the High Court has said that lordship,
Do you have BEd?
I have here.
So earlier the issue was that BEd was not a mandated qualification.
Yes, lordship.
But for the feeder post, BEd was mandated.
Mandatory
Then this court division bench, Justice Bopanna, forgot who was there, said that BEd would be a mandated qualification. Direction was given to amend the rules. This is after that.
Yes, lord. This is for us before that, your lordship. This is
Okay, this is before
2013,
that.
lordship. Here, what we are challenging, lordship, the qualification for a higher post cannot be, lordship, higher than the lower post, your lordship.
Okay.
So what happened, lordship, is for the post of sub-inspector, the qualification much more
I got it.
stricter.
That's what.
Yes, sir.
I got it.
This is
Okay.
one of the grounds, your lordship.
Okay. When?
Lordship, any on a hearing day, lordship, because it will take some time, your lordship. Must also like to.
But
argue
the
this
parties
matter.
at length list this matter again on 14/5/2023. We take it for admission hearing itself.
Admission, hearing,
Admission.
your lordship.
14/5.
Much
Both matters, huh? Don't know.
Maybe. In this case, my lord, ready for.
It is stated at the bar that the pleadings in the matter is complete. Accordingly, the matter can be taken up for final disposal, right? Mr. Sharma, We can take up the matter for final disposal, right? List this matter again on 21/5/2024 in the admission column. 21/5. Yes, Mr. Vuya.
My lord,
You have got anything?
no, my lord, I need some preparation to satisfy my lord, in this case. My lord.
Honorary teacher in a provincial high school.
But my lord, kindly appreciate one small thing, my lord.
Hmm.
Honorary teacher in a provincialized school is prima facie not permissible, my lord. But the manner in which the department has utilized me.
That's a different question altogether.
My lord, that's why the legitimate.
As far as this court is concerned,
My lord,
I'm bound by the judgment of this court.
my lord, my lord.
My Lord Justice Gogoi's judgment. I'm bound by that. I think there is a division bench judgment also to that effect.
I have annexed some of the judgment of my lord
But
in my
that's
petition
to
also,
the
my lord.
point.
Here is also the same, my lord. That's why, my lord, I need some effort to satisfy my lord, my lord.
Mr. A.R. Bhiya, learned counsel for the petitioner submits that he be accommodated for the day and the matter be adjourned and taken up on
On my lord, after.
after 10th, any day. 14,
My lord.
14/5/2020. Prayer accepted, leave this matter again on 14/5/2020. You see whether you can satisfy us that there is a way out.
Yes,
Another perspective you can give. We will look into it. Don't worry.
my lord, they have even regularized me also, my lord. Oblige me.
Affidavit to Isani. Who does it? No,
May I please, your lord.
just a moment, Mr. Sharma. What is it? Just let me go.
First order.
Yes, Mr. Das. Where is that impugned order, Mr.?
Yes,
Sharma?
23/3.
Page,
203, Lord.
Page 70. 203. No. Page number. No. This addition.
Affidavit, in my affidavit, Lordship. Lordship, it is the page 70. The status quo order is of 23, Lordship. Now on 17th April, now they've started.
Yes, Mr.
And
Das.
Lordship, let
Mr.
me
Gogoi,
be very clear on that.
what is this? We are considering this matter. We asked you to maintain status quo. Now there is a.
Probably, Lordship, it is not to the knowledge of the.
No, it is said here that somewhere the allegation is that, where did you get it, Mr.? And the standing council gave his opinion stating
Lordship, I
that
have
there is no
given-
impediment.
I have given, Lordship. I have given opinion is with me, Lordship. It is Lordship in long back, Lordship.
Huh?
Not after the status quo order, Lordship, long back.
Long back.
Long back, Lordship. I have given, Lordship.
And
That
after
you are
that,
rightly given, because status quo order we passed
Lordship,
only
it
on
was,
23.
yes,
it was given
it
on
was long
7
back.
Huh?
It
No,
was
no.
He has given long back.
on 7/9/23, Lordship.
What is this? This thing shows that there is something else to the whole issue.
Not only
That
that,
day,
Lordship,
Mr. Sharma was indicating, now it is getting established.
Lordship, probably, Lordship, it is not to the knowledge of the authority, Lordship.
Maybe.
That is there.
Do one thing. First and foremost, let us go back to the place where we were.
Lordship,
You withdraw this.
Lordship.
I'll give you time.
Lordship,
You withdraw this.
Lordship, on the basis of my lord order, Lordship may stay.
No, I'll not. I'll not. I'll draw contempt. I'll not state, I'll drop contempt. But before that, I'm giving you an opportunity. Withdraw this order. Anything else, Mr.
Yeah,
Only
next
this
page, Lordship, page 71.
71.
Again, because the date is fixed on 25th, the case date, so they have fixed it on 25th. And Lordship, what they have said, that you know, in the criminal jurisprudence, when you get a bail for the Sanmari case, you will be arrested for a Borulu case. Now in the service jurisprudence, we will start this.
Let them do that better.
If you get the relief from the court for the earlier search sheet, we'll start with the next.
Mr. Sarcastically speaking, not bad for the advocates.
Earning law. That's why, Lordship, in this case, Lordship,
This cannot.
I make a start.
There is a
I'll
production of
make
one
a start,
IL.
Lordship.
It is a production of one IL. For that lordship, page 70 lordship, one IA was lordship, bond lordship.
Okay, when can you get this redone? We want page 70 and 71
Lordship.
to be undone.
Posted it next week or after 10 days.
Okay. Mr. Sharma,
After 10 days.
let them do it. Because if I pass an order tomorrow, they may come up with something else.
Lordship.
It has been brought to the notice of this court.
This list, Lordship, will show
Hmm.
what this respondent number 4 is doing.
I know.
It is another thing, otherwise lordship, something is there, otherwise lordship may fix the matter for final hearing.
No.
I'm ready.
First.
First lordship, that will withdraw lordship and that
That you will have to.
I'm ready, Lordship. Last day. also I
Mr.
started matter.
S. Sharma, learned senior counsel appearing for the petitioner, by referring to the additional affidavit filed on behalf of the petitioner, submitted that in spite of the directions passed by this court, wide order dated 23/2024, directing the parties to maintain status quo in the matter, and the continuation of that order, and continuation of the interim directions, the order dated 9/4/2024. The Secretary to the Government of Assam, Higher Education Department, a notice dated 17/4/2024 has required the petitioner to submit his explanation in the matter as to why he was not purportedly cooperating with the inquiry officer appointed in the departmental proceedings presently pending against the petitioner. Full stop. It is further, on the same date, a further communication has been issued by the Secretary to the Government of Assam Higher Education Department to the principal, VRM Law College, requiring, intimating the later that the undersigned would, that the said authority would visit the college on 25/4/2024 at 11 AM to inquire into the complaints submitted against. The principal is the petition. To the petitioner, complaint against the petitioner, full stop. Such a course of action as adopted by the respondent authorities in the matter in the view of the court is in clear violation of the directions as passed by this court on 23/2024 and continued while the order dated 9/4/2024. Before proceeding to take any further, action in the matter for violation of the directions passed by this court, the Learned Standing Council, Higher Education Department is granted an opportunity to impress upon the respondents to take a remedial action in the matter and place the same before this court on the next date of this week. In the event the orders dated 17/4/2024 and or a similar and or the action as contemplated in the communication dated 17/4/2024 is continued with further course of action, further orders as would be called for in the matter would be so passed on the next date of listing. List this matter again. When, Mr.
On 10th lordship.
No. Friday, because we'll hear the matter.
Lordship.
We want to hear the matter.
Yes.
On 14th.
14th lordship.
14/5.
Lordship.
And I want
Lordship.
this both to go.
Probably
And
lordship.
I may not be correct in using these words, but I'm requiring you, I want it to go.
That will
This
go.
is not done.
Both will go, Lordship. It is definitely
This is not done.
100% both will go.
Once
Probably
we have passed the status quo order, you have any problem, come to us.
They cannot, Lordship.
You come to us.
They-
We are
even-
here.
Even probably, Lordship, that was not knowledge of the.
Mr. I'm not sure.
Yes.
Mr. Gogoi, it gives an impression that this man is proceeded against. There is a vengeance against him by someone.
It is there, Lordship.
And it's not much delayed we are here.
I'm not saying that, Lordship.
You impress
Something is
upon
there,
him.
Lordship.
You impress upon him.
Something is there, Lordship.
It may be with him also, I don't know.
Something is there, Lordship.
But this is not the way you do.
No, that will go, Lordship.
On 14, we are taking it up for final hearing.
Lordship, that will go, Lordship.
In the meantime, the status quo will continue.
The interim order passed on 23/2024 shall continue until further.
Lordship. Oblige, Lordship.
I'm grateful.
What did you mean? What did you mean? Mr. Mr. Bora, you get hold of Mr. Soikia so that the other matter can be taken up.
My lord, he is on legs, my lord, in court number 4.
Okay, let him come.
My lord.
Let him come. Ivan? 36.
It is the second round of litigation, my lord. The state scrutiny committee rejected the claim of the petitioner, my lord. 26, page 59.
Yes, what is your stand?
Lordship, in this matter, we have, Lordship will kindly come to page, the last page, Lordship, which is page 59. There, Lordship, in compliance of the contempt order, Lordship, an order has been passed, Lordship, in where reasons have been given, Lordship. In view of the above, the facts and circumstances, the name of the petitioner, Dukhiram Ray, was not recommended by the DSC under the clause 13(6) of the 17 Act, and therefore the SLC as well as the joint committee could not recommend the name of the petitioner for provincialization of services as per the 17 Act. Therefore, my lord, his claim, this thing was rejected. My lord, here what has happened is if 4 people's name have been recommended, my lord, by the DSC.
What is the date of the speaking order?
Lordship, this
Page 59, my lord.
59.
59.
19/5/23, Lord.
19/5.
And what has happened is, my lord, he is claiming for social science teacher. And whereas the person who has been provincialized is Ratna Kar. She is, of course, as per his claims, that junior to him, but we are not sure as to what he used to teach there. As per our records, my lord, Ratnakar was teaching social science. And accordingly.
Notice has been served on Ratnakar?
Already died, my lord. It is observed in the past. He already died before provincialization, my lord.
Okay, that case,
My lord. Case 50, my lord. It is dishonorable already clearly observed, my lord.
I got it.
He died on, my lord, 26/8/2019, my lord. And
Okay, list this matter again on. For 2024, we'll dispose it upon.
my lord. Oblige.
I've given
You can keep it, you can give it to me.
my lord.
And next date, explain what you want to say from.
I'll bring in the formal affidavit.
No need. Just tell me what is written there.
My lord.
I'm not understood.
I know.
So, क्या है इसमें? तो क्या आना का? पीछे से क्या नहीं? What is the immediate problem, Mr. Sharma?
My lord, immediate problem is that our examinations are scheduled to be held by 27 to 29.
27 to?
27 or 29, by 27 or 29th April. So going to.
Where is that IA?
And my lord, there are IAs, 4 IAs are there. Along with item number 39, 40, 41, 42. In the IAs, I have prayed that.
Yes. What do you?
Lordship, this method is conducted by Mr. APD. Lordship, he is busy because his father is hospitalized. So he could not come before this court, Lordship, today. And Lordship, we have received the original copies of the records. Lordship.
IA. Examination.
Lordship.
Yeah, IA to the option. Which case first IA, Mr. 1152/2024?
1152.
Itu the second. See, 38 to 39. Mr. Kotogi is not here.
Not here, Lordship. Lordship, as per my instruction, Lordship, these students were given the interim order to attend the classes, but they have not attended classes. Mr. This Adesh Kumar Patra and there is Kumar Gaurav, Lordship. They have not attended classes, field it, Lordship. Though there is interim order passed by the Honorable Court.
39. You have an IA in 39?
39, 40, 41, 42.
40, 41, 42.
42.
39 to some.
Yeah. 62. 63. 52. 50.
You want a modification of the earlier orders also?
My lord, that problem is that Honorable Court has allowed us, your lordship has allowed us to attend classes. They have allowed me to attend classes. They are not taking our attendance. They are not allowing us to registration. Without registration, we are not able to sit in the examination. So my prayer is that let them allow our registration and let we allowed to sit in examination till the matter is disposed of. Till that they have not filed the affidavit in the main case also. They have been directed to file affidavit. They are not.
When is the exams?
My lord, exam.
Yes, when is the exams?
Exams, as per the representation, Lordship, 27.
27 Sunday.
Start from 27, Lordship.
27 is Sunday. Saturday, okay.
Saturday.
Okay, allow them to sit, but don't declare the results. Young guys, whatever punishment is there, we'll see. But why do you prevent them? Let them have that. Tomorrow, if we say that they are not guilty, they are liable, then who will give them back the time? Let them appear in the exams. Right? But Mr. S. Shamal on a counsel for the applicant, we are not disposing of the IA. We are keeping it at ad interim order. Okay? You come back with your plea. And we find that they are not entitled, fine, we will undo this. Also, Mr. Sharma, by referring to the order dated 14/3/2024 passed by this court in the connected writ petition, being WPC number 879/2024, has submitted that this court had permitted the petitioners to attend their classes till the final decision is taken in the matter by the authorities. Full stop. Mr. Sharma submits that in spite of the said order, although the petitioners were, Mr. Sharma submits that in terms of the said order, about the said direction passed by this court, the petitioner was allowed to attend his classes. However, his attendance was not being taken by the college authorities. Full stop. Mr. Sharma further submits that which is the exam?
3% for third year and one.
No, one more one will do. This one, Ashok Kumar.
My lord.
Ashok Kumar Patra, Adesh Kumar Patra.
Adesh Kumar, he is third year student, my lord. He is 6th end semester exam.
It says contents. Kya likha? Mr. Sharma submits that day. No, full stop. Mr. Sharma further submits that the 6th semester final examinations of the petitioner. 6th semester final examination?
6th end semester exam.
No, 7th you have not said.
Final exam.
6th semester final examination of the petitioner is scheduled to commence from 27/4/2024 or on a date proximate thereto, and the petitioner is not being allowed to take this said examination. Full stop. In view of the fact that this court had already allowed the petitioners to attend their classes, full stop, comma, this court is of the view that the petitioners, the IIT authority, IIT Guwahati authority shall allow the petitioners to take their said 6th semester examination. However, the results of the said examination be not declared without leave of this court.
My lord, registration is required, my lord. They may allow us to register.
Full stop. The IIT authorities for the said purpose shall take all requisite steps facilitating the petitioner to appear in the said examination for his 6th semester papers.
Including registration.
Everything. Why only registration? Whatever is required, everything.
Yeah.
So this is done. List again after 3 weeks on a date to be fixed by the registry.
Lordship, in all the matters, the authority decided and the fresh order passed on by virtue of 1/4/2024.
You have not brought that on record.
No, they have brought this record on.
Fine, let it be. We'll see. We'll have to
The
consider
earlier
that.
order, Lordship, already earlier orders passed by the authorities have lost its force because the new orders passed by authorities.
New
on
punishment has been imposed.
Yes,
What is that punishment new?
means Lordship, they are now allowed to attend the placement. They are allowed to sit in the placement and others. And
Only some modification in the punishment only.
Where is that modification?
Lordship,
My lord, it is
others from.
Annexure 10, my lord.
Page
Others
26.
my lord, Annexure 10, my lord, of
Page-
the IA.
Page,
Annexure 10 of
page,
the
Page
IA.
26, Lordship.
Page 26, my lord. They have only considered two punishments, my lord. That is, you are allowed to avail hostel.
Okay, go and sit in your examination.
Sir.
Next, item number 40.
Hmm.
Yes, Sharma.
Yes, sir.
40. Is IA number 1163/2024. He wants what?
He's
I-
4th year student, my lord.
He wants
He's 4th year student, my lord.
fourth,
4th year student here.
fourth
He's my-
semester,
No, he's 8th semester.
eighth.
8th,
Be very careful.
8th.
Eighth खाली कर देना, बाकी एक ही रहेगा, 8th semester. ठीक है? And the order of this court, earlier order of this court,
My lord. That is
same
my
day.
lord. Same, my lord.
Where is that?
My lord. I'm sorry, my lord.
Okay, 14/3/24.
14/3, my lord. Same.
Hmm?
Same day.
ठीक है? खाली WPC नंबर बदलेगा. यहाँ से ले लें. WPC नंबर यश शर्मा 674/2020. Address आपका होगा, right? Next one,
Next is IA 4393. Pradum Dixit.
Pradyuman Dixit for IA 1150 2024. Here the order is
Regarding Pradum Dixit, he is your 6th semester.
6th semester.
6th semester. The order is same day. Same.
No, writ petition, wait.
Order is 14/3.
No, that order is not here.
My lord, 43,
repetition.
Annexure 9, my lord.
Imana, what was the IA 1150 676? 676 is Gaurav. No.
My lord.
Pradyuman. Where is that order from this court?
It is Annexure 9. Page 17.
No, where is the order in the case of the petitioner? 696. There is no order.
My lord. In
The
case of,
order in writ
My lord,
petition, connected writ petition.
in case of my lord, Pradum Dixit. Pradum Dixit. Yes, my lord.
676.
Yes, my lord. Order is there, my lord.
40,
Order is, one is 14/3.
but it's not there in his writ petition.
Not in petition, my lord. IA. In the
Which
IA. my
IA?
lord.
1150.
Yes, my lord.
No. The order that you have annexed here at page 9, annexure 9,
1150.
show me 676 there.
My lord, it's page 17, my lord, is here.
17, 676. Where is 676?
Yes, sir, ma. 6, oh, yes, sir, man. My,
Okay.
in fact, in fact, it is a common order.
Common order.
Common order.
Same thing. In writ petition number 676.
Equal density.
And he is, Pradyuman Dixit is
Sixth semester.
6th semester. One more. Kumar Gaurav, 1162. He is which semester?
He is 6th semester.
6th semester.
6th semester.
Okay. So list this matter again. Analogous one. List this matter again also. Done with?
Then, my lord, one is the Yes Raj Verma, my lord. He is one admission item number is 37.
37.
I'm to bring the
37.
instructions. Yeah, 37.
37 listed.
In this case, there is no IMI.
No, but listed.
No interim
37
order was
listed along with WPC number 656 to 2024 and 674 2024.
Hello, interestingly, in this case, my lord, person has come from his native village on 12th of August, and he has been said to have been involved in the incident of 8th August.
That we'll see in merits. Now, go and sit in the exams.
My lord.
Hey, to material. I say really material.
My lord.
Mr. Soikia, you can make your submissions. You take notes. Because he has completed, you can make your submissions. Let them take the notes.
So basically, what is his case? That without following any process, he basically says that he was terminated. In fact, it is not a termination order.
That records were produced by Mr. Bora.
Yes.
You did not go into the truthfulness of that.
Yes, we simply, because
Notice
if
that.
we go into it, it will be detrimental to him.
No, you noticed it, but you said that you are not going.
Absolutely. And that is permissible under the norms of the department. No, now, what is the impugned order? Impugned order, Lordship is pleased to look at. At page 52. Mr. Gyas Ali, Finance and Accounts Officer, SSA Dibrugarh, is hereby released from the contractual period or service on account of his lapse of contract agreement with effect from 30/11/2022. So his contract was till 30/11/2022. So once it is over, we released him. There is no stigma, nothing here. But if you dig now, then this order, if Lordship is pleased to interfere, suppose, assuming, then we have to give a detailed order, which will be detrimental for his all future scope of employment. So in fact, we have done a very good thing to him. The way he has conducted himself during his service there, Lordship knows, he diverted all the fund to another office of another
Along with one
employee.
accountant. Along with one accountant.
Exactly. All the fund. And he is the head of that department. He is the Finance and Accounts Officer. So he was arrested. It is not that he has a very clean record. And it is not that we have not done anything. We have given him an so cause notice. He explained also. So prima facie, the principle of natural justice was followed. But no speaking order was passed in respect of that proceedings. If we have to pass a speaking order, everything will come into the public domain, which will again go against him. It's an open and shut case in case of him. Now, the MD of SSA has the authority in respect of Finance and Accounts Officer, whether he wants to allow him to continue once the contract period is over or not. That all he will have to take. That document also, it was already submitted before this Honorary.
Service regulations.
Service
and financial regulation.
yes, service
2008.
regulation, yes. Here, serial number 8, internal page 9. Continuation of employees on deputation, attachment, and further engagement of employees on contract in mission service.
You are reading, Mr.
Serial number 8 at page internal page 9.
8, continuation of employees.
Yes.
Okay.
After successful completion of the term of the agreement or deputation, mission director will following procedure and arrange for continuation of employees on deputation, attachment, and further engagement of employees on contract in mission service. EC will be informed once in a year regarding deviation made, if any, from the prescribed process of continuation, numbers, and category of employees who have been allowed to continue in mission service. Now, in respect of Finance and Accounts Officer in internal page 11, serial number 42. Finance and Accounts Officer, decision on continuation of employees on the deputation, attachment, and further engagement of
Pardon,
employees.
Mr. Soikia, you're reading?
Page 11,
11, okay.
serial number 42, up in the top column.
42.
F and
Finance and
CO.
Op. Okay.
So the decision on continuation of employees on deputation, the third paragraph, and further engagement of employees on contract in mission director by MD. So MD is the authority. He does not have to give any, but he will have to inform the EC, that is the Executive Council.
Every year.
Every year. And there is another process of annual appraisal also. If all these things are required, Lordship, we can definitely disclose it. But which against it will go against him. Now, from the record itself, it is very clear that he is trying to give the color of this impugned order of June 19th at page 52, that is a termination order. From the plain and simple language, there is no ambiguity that it is not a termination order. Neither it is a stigmatic in nature. So it is, once the contract period is over, we have released him. So we have used the word release, so-and-so is hereby released from the contractual service, and we have given the reason on account of his lapse of contract agreement on 30/11/2022. If we have to, suppose we have issued the so cause notice. Here there is a reply. What is it? So cause notice.
The reply is at page 45.
Page 45.
The
Now,
relevant would be page
let me
48.
go chronologically. Now, his case is that one of the ground is that we have to follow the procedure of the Assam rules, this executive, Assam Service Discipline and Appeal rules. So at page 31, what is adopted that we have to follow the spirit. Save and otherwise expressly provided, this is page 31. In Service Regulation of Financial Year 2003 of Assam Sarva Shiksha Abhiyan, it is hereby notified that spirit of the rules and procedures as prescribed under so-and-so 1964 followed by Government of Assam for enquiry, departmental proceedings, award of punishment, appeal, etc. shall be followed by Assam Sarva Shiksha Abhiyan mission as and when enquiry or departmental proceedings are required to be conducted in respect of any employee, contractual or otherwise employed under so-and-so. So we basically have not conducted any departmental proceedings against him. We sought an explanation. So what we have done, once that FIR was registered,
The fire is at page 32.
yes, Lordship, page 32. When this FIR was registered and lodged by Binti Sharma, Inspector of Schools, Dibrugarh, with due respect, I would like to inform you that after scrutinizing the fund release to schools, etc., with the bank transaction statement of our savings bank account number so-and-so, Dibrugarh account number so-and-so, it has come to notice that some funds released to the school's persons concerned credited to account number so-and-so of UCO Bank, of Choki Ding and so-and-so of Indian Bank, Dibrugarh, which does not belong to the school or the person concerned for which funds were released in April 2022 to March 2023. After verification of the aforesaid mentioned accounts numbers of the office concerned, it has come to know that the bank holders of the aforementioned bank accounts are Dhonti Gogoi Phakia, working accountant of District Mission Office of Samagra Shiksha, Dibrugarh, Tulsigaon, Dibrugarh. So when this FIR was registered, then thereafter, he was also given a notice under section 41A at page 33 for giving his side of the story, because he was the head of the accounts department. He was the finance and accounts officer. Then he was subsequently arrested, page 34. Date and time of arrest, Lordship will see after the column. 4/5/23 at so-and-so. Then he was forwarded also to judicial custody and he was granted bail thereafter, after his detention for several days.
He was there for more than 48 hours.
Yes, at least. So now, when after his release, I think it is after the, yes, after his release, the concerned inspector of schools sought the file of RIDF file, that is the regarding the fund allocation at page 39. Regarding file RDF, it has been noticed that you have stated in your reply submitted on 20 May 2023 regarding RIDF, which you have discussed with me, but it is clear that you have not discussed about the matter with me. I have not received any file relating to RIDF from March 2023. You are hereby asked to submit the clarification about the missing of RIDF file. That is one aspect. Thereafter, a clarification regarding that he has submitted. Not very relevant now, page 40, regarding the clarification regarding the file. That a so-cause notice was issued at page 43 to him. It is reported a total number of 29,30,634 has been fraudulently withdrawn from DMO Dibrugarh so-and-so to against 42 number of transactions during the period from January 2022 to April 2023 and credited to 3 numbers of individual personal account of Honti Gogoi Soikia, accountant of DMO, etc., etc. So all these funds were transferred to another official, another employee of the same department under him. And Honti, when she was arrested, she disclosed everything. She has done it at the instance of this petitioner. So after coming to all these things, which are very clear without any doubt, because these are based on documentary evidence. He was arrested, Honti was arrested, and the MD has come to a conclusion that this kind of persons should not be allowed to function anymore. And therefore, once the period of contract, all these things happened in May and June of 2022, but he was released much later. Sorry, he was released on 19 June, although his period was over on 30/11/2022. He was not given the extension. So in that situation, two legal question arises, whether he can approach this honorable court and seek extension of the contract period. The law is very well settled, Lordship, that once the contract period is over, there cannot be any mandamus for extending the contract period. That is the law well settled, number one. Whether any arbitrary action has been taken in not granting him the extension because his other colleague employees or identically placed these finance and accounts officers of other institutions under the Shiksha Samagra, they were given the extension. There is a distinguishing factor here. The distinguishing factor is that he has involved himself in some criminal activities, the others have not. So the MD can take a call under the service regulation that whether to continue this gentleman or not. He has exercised that power and terminated, did not extend it, not terminated. He did not extend the contract period once it is over. Had it been during the contract period, we have to terminate him, things would have been different totally. In that situation, although a detailed inquiry like as it is given in the 1964 rules.
At least some reasons would have.
Yes, that is the law well settled. So in that line, I'd like to place 2 3 judgments because now it is a pure question of law now. Whether he can be extended and whether we are...
First ground may not be possible.
Yes.
The second ground, if this court comes to a conclusion that he was discriminated against, then we can remand back the matter to you for a fresh consideration.
Now, page 45, he was given a show cause notice. Sorry, page 43. He was given a show cause notice regarding all these things and he has given a reply.
Yes.
Clarifying his stand, but this is not satisfactory. So we have to pass a speaking order if at all.
This would have.
If at all it is required. But if it will go and it will be detrimental to his interest, if Lordship directs, we'll be more than happy to pass a detailed order because the spirit we have to follow. What is the spirit basically? It is the following of the principle of natural justice.
Here the whole procedure need not be,
procedure
need not be gone through.
Absolutely. In fact, we have adopted it, but the law is also passed by this honorable court, by my Lord Justice Rao, that for contractual employees, that is also not required. And under the contract, what is there in the contract? That 1 month's.
Notice, 1 month salary.
1 month's notice.
And salary or salary in use.
Yes, page 27. During the period of contract, serial number 5, serial number 6.
6.
If the first party has to terminate the agreement at any point due to misconduct, insubordination, dereliction of duty, misreporting, misappropriation of SSA fund, or negligence in duty by the second party, the first party shall proceed in terms of the order dated so and so, 14/8/2015, to terminate the second party, and the first party in doing so shall not be liable to pay 1 month's remuneration advance in lieu of notice of the above. So that option, because we have to conduct an inquiry in case we have to terminate him during the pendency of his contract period.
But
so now, as the period is over, that is also not required. And 5 says, the first party may terminate the agreement if it finds that a service rendered by the second party are unsatisfactory, and if there is any breach of the terms of the agreement. In such circumstances, it will be open to either party to terminate the agreement by giving 30 days notice to the other party in writing, or by paying 1 month's remuneration in advance in lieu of
terms
the
of
notice.
your submission, that situation is not there.
Either of the situation is not there. Either of the situation.
What are the judgments you want to rely on?
Yes, Lord. My Lord Justice Sridhar Rao judgment 2015 4 GLT, page 673. Paragraph 14. May I just read this, Lordship? In view of the above discussion, it becomes explicit that the termination of the petitioner was not an arbitrary act without adhering to the principle of natural justice. So cause notice was issued to the petitioner, and he did submit his explanation. Content of the explanation fully justified the order of termination. It is to be seen that the nature of inquiry that is required to be done in respect of civil servants and Article 311 of the Constitution need not necessarily be adhered to in contractual employees. This is the line I am trying to emphasize. I'm giving a copy of this, Lord. It is not required at all, but we have adopted. So we have to do it. But that situation has not fructified in our present factual matrix. The next case, Lordship, another learned single judge's order, UB Saha, my Lord Justice order, of reported in 2007 to GLR 828. Here the paragraph will be 8.
Okay, same lines.
Same line basically. Here also it is said, may I just read the relevant portion? The last portion of paragraph 8. Doctrine of discrimination is applicable in case where enforceable right of a citizen is existed. In the present case, the petitioner have no right to be continued to the post for which he was engaged unless the authority extends the period of the engagement. That is one aspect. Hence, violation of the provisions of Article 14 and Article 311(2) does not arise, particularly when contractual engagement itself clothed with conditions made therein. Therefore, the order of cancellation of the order of engagement to the petitioner by annexer so-and-so as valid and reasonable, nothing for interference of this court. So, inquiry is not contemplated also. And 2019, 6 SCC page 250. Rajasthan State Roadways Transport Corporation versus Paramjit Singh. The judgment is authored by the President Chief Justice of India. Paragraph 8 and 10. The terms of the appointment indicate that the respondents were on purely temporary contractual appointment, and the services could be dispensed with without any notice at any stage. Having regard to the terms of the contractual engagement, we got to the view that the action of the applicants cannot be faulted. So we have also not violated any of the terms and conditions of the contract agreement. Then 2018 free SCC, page 218, Jogesh Mahajan versus Professor RC. 2018.
3 SSC 218.
218. Here paragraph 6, 7, 8.
Same
It is basically that they don't have any enforceable right for extension of their contractual. And other case also on the same line, another 2023 1 GLR, page 437. Imran Hussain Khan versus State of Assam.
2023 1 GLR.
Page 437. My Lord Justice Michael Joram Khuma.
Paragraph?
Paragraph 14 and 16. And a very famous case, Ajoy Kumar Haloi, 2014. 5 GLR, page 560. Paragraph 11 and 12.
Okay.
So basically, this is my humble submission.
So if I've understood you correctly, you're basically two-pronged submission. One, that we have not terminated him.
Absolutely.
We have, on the completion of the contractual period, we have examined
and we have
under
released
the power given to the MD and noticing something. We said you're not fit, we thought. So we have
that also we are not disclosing.
No,
yes.
no, that's not the foundation. Just
Yes.
a thought. And you allowed him to go. So in that view of the matter, there is no termination, no stigma. And you have exercised your right in terms of the agreement and the regulations.
Absolutely.
So he can have got no grievance with that. Second part is the discrimination, which he is alleging that his case was not considered for extension, although he was working for a long time. You come up and say that now that period is over. This court would not have the power to proceed to direct for extension. It could have directed for a consideration, but for that you say that the conduct which is there, which did not find favor, has also to be weighed in by this court. This is basically the underlying.
Yes, now regarding the discrimination part, we have extended the contract period of other identically placed officials, FNCO, about 30 or 28. The distinguishing factor here is that they do not have any police case. They were not arrested. They were not involved in any misappropriation of funds. That is our reasonable.
I'll put it in this manner.
Yes.
That there were 31 FAOs available.
Yes.
And you found 30 to be eligible for your organization.
Yes.
You did not find the 31st to be so eligible.
27. So 27, 28 we have not done. Page 54. So we have extended in
because that note of the MD, or I think ED, whoever it is, was brought on record. And it was said that, however, without going into the truthfulness of the said allegation against both of them, I, being the appointment authority, do hereby release so and so on account of expiration of the above noted deeds of agreement dated 30/11/2022.
It is record. Yes.
The copy was given to.
Yes, you have to go. In fact, he did not show this.
That's why I was worried. Why were you not referring to this?
Now he is. So this is very clear. So application of mind is there.
I was thinking why Mr. Saikia has not hit
this
on.
is for the first time I am.
I thought you did not. You wanted to come to that last.
No. The thing is very clear. Application of mind is there. There is no malafide. We do not have any.
We'll hear Mr. Saikia.
Yes.
And
so
then
my
we will
colleague will be here, Lordship. Highly obliged.
Thank you. You have taken it.
Yes.
You have taken down the notes. Ask Mr. Saikia to respond. 45, 46, 47, 48. We have already dictated that orders in the yesterday's case.
Already dictated.
We have said that now that the Act has been applied.
Yes.
Your cases will be considered by the
Autonomous body.
KAC authorities strictly in terms of the provisions of the 2017 Act. And we have, I think, given a time frame also. Only thing now that individual applications, you have to submit your particulars to the Secretary Education.
Education,
Kabyang law. That much only.
Okay.
Will do? You need not wait. We'll dispose of this matter. 44 to 48. Dispose
So far-
because of delay.
So
Yes.
far, the item 12 to 14 are concerned, my lord. That
12?
your worship earlier judgment that copy.
Ha,
we
ha,
have got.
ha, ha.
I think, my lord, I may try to convince your worship to take a different view.
Please do so.
So let it be some other day. my lord.
No, no issue. I'm open. I'm open. Because that was my view when I was that side. And the contrary view, Mr. Gogoi has forced me to take when I came this.
Otherwise also, lordship, this issue was also decided by the honorable division
I know.
bench of our High Court.
I know,
lordship.
and because I always had this impression that university system, once somebody is in a university system, the UGC norms at that point of time will be applicable, and if he continues, the subsequent UGC norms cannot be made applicable. But he placed certain judgments which I had to just seems so.
Because my
Sorry.
lord, the question that will perhaps call for consideration is when was the vested right accrued?
I will try to modify it further that whether a person who is already in the university system would be required to acquire the subsequent qualifications. Because see, a college, again, maybe a little bit, my judgment, that judgment, it may go beyond that. When a college is set up, the college directly is not under the UGC.
Yes.
It is, the UGC exercises its power on that college through the affiliating university.
Yes.
So you have to have all the UGC norms for having the affiliation.
True.
So in that view of the matter, whether I think you can also address whether a difference can be made between a government college and a private college, a venture college.
Venture college.
So the venture people, when they come, when the government takes over, whether say in a college like Biburwa, Ajja, a person who joined maybe say in 2000, he'll be covered by the regulation at that point of time. 2008, we have a fresh regulation. 2010, we have a fresh regulation. Then 15, 16, 18. Now that person may not have that qualification. But university guy, all the regulations that UGC publishes, there is a line, this will not be applicable to persons already in the
University system.
Now, if he wants to become the headmaster or the principal, then
Yeah,
that will hold.
Yes.
Then if its date of say senior scale or selection grade falls within a date after the proclamation of that UGC notification, then that will apply. But for continuation in service and the same capacity, whether that can be. Try to address me.
Yes.
Mr.
Because
Gogoi will also.
There are certain decisions of our High Court which says that under the 2011.
No, there is a division bench for that.
Yes, my lord. There is a division bench order also, my lord. I'll place all those, but your worship will give me some time.
No, no problem. When do you want it? You tell me. Mr. Gogoi also be there.
Sometime in the month of May, my lord.
Whenever it's convenient to you. Item number 12 to
12 to 14.
14. Item number 12 to 14. Huh? Yes, number gita report my diba. On the prayer of Mr. Heard Mr. M.K. Chaudhary, Learned Counsel, Senior Counsel, assisted by Mr. M. Sharma, Learned Counsel for the petitioner. Also heard Mr. K. Gogoi, Learned Standing Counsel, Higher Education Department. And Mr. Sharma Goswami are appearing.
No, so much there, sir.
Soma, also heard Mr. K. Somuha. A. Somuha, Learned Standing Counsel, UGC. When?
My lord, either 29th or 31st of May, my lord.
May. List this matter as prayed for by the parties. List this matter again on 29.
My lord.
Let it be 30. Thursday.
My lord, motion day.
No, 30.
Tuesday is Thursday. Tuesday is Thursday.
Thursday.
Oh, Thursday, yes, my lord. Let it be on 30.
305 2024.
Apply.
30 is Tuesday.
No, Thursday.
Thursday.
Thank you.
Oh,
Oh, sure.
He is otherwise also 2 days back every day.
I have a small payable, so your lordship proceed. I don't know 17, 18 analogous, my lord. I'm paying for an accommodation. Can it be a 9th, my lord? Would you concern about both sides, my lord?
You are for?
I'm in the item number 18 petitioner.
We have fixed it specifically today.
Well, my humble prayer of your lordship's my lord.
What is the issue? What was the issue?
The seniority dispute for the post, regulation for the post. So,
Mr. Borbia has not come.
No, Lordship, some personal difficulty.
He has also difficulty. That is why.
Okay. On the prayer of the parties, list the 17, 18 day. List this matters again after 2 weeks on a date to be fixed.
Any date may be fixed, 9th of May.
All filled up. We wanted to dispose of this matters today. Okay, fine, no problem.
Much obliged.
This matter, lordship, relating to insert states, headmaster lordships.
Yes.
Lordship, by an order dated 31/1/2024, lordship will get page 30, lordship.
Page 30.
Page 30, lordship. This is the impugn order, lordship. By whom
1-3.
Director has.
No, page.
Page 30.
Item number?
Item number 38. I am.
IAC. Page 30.
Page 30, lordship. This is the order by which the inspector of school was allowed to hold the charge of headmaster, lordship. And petitioner, being the senior most teacher, lordship, by the next page 31, lordship, he was allowed to look after the academic affairs, lordship. Lordship, thereafter, lordship, for a moment, lordship, page 28, lordship. Serial number 1 is the petitioner, lordship. He is the senior most teacher as per panel prepared and submitted by the.
The interim prayer was rejected.
Lordship, that we have stated in our IA, lordship. Your lordship was pleased to issue notice for interim prayer. That was rejected, lordship, because we could not show anything, lordship, of that sort. That's.
Have you taken steps? Notices have not been issued here.
No, lordship. Your lordship.
Heard Mr. R. Islam, Learned Counsel for the petitioner. Also heard Miss H. Taranpi, Learned Standing Counsel, Secondary Education Department, right?
Yes, sir.
Also, issue notice returnable 4 weeks. You take steps, we'll see. Once it has been rejected, we'll not come in again.
No.
Issue notice returnable, writ petition, okay? Returnable 4 weeks. Miss H. Taranpi accepts notice on behalf of the respondent number 1, 2, 3.
All respondents.
3.
4 as well.
On behalf of all the respondents. No formal notice is to be issued. Also, petitioner to serve requisite extra copies of the petition upon the Learned Standing Counsel. Also. Writ petition WPC 65.
Lordship, earlier your lordship was pleased to issue notice earlier.
That has been finished. I 1000 next order was given. I bracketed C number 108120. Second to my one. List this matter along with WPC number 656/2024. Once it is rejected now without hearing the party, how can we come?
Obliged.
Baki case, no?
May I please your lordship?
Hmm.
Lordship, here, my lord, we have enrolled the file to the finance department, my lord, for the approval. As we receive the approval, then we shall.
Okay, something has
also-
happened now.
My lord,
Something has happened.
but my lord, there is a vague letter, my lord. There is no specific date, my lord.
Forget it.
Who
They
have-
have done it. They have done it.
Well-
We'll not, don't always have a suspicious eye. They have done something.
No, here, my lord.
We wanted the
Bottom line,
matter to-
24 year, that is here, my lord. My lord.
We wanted the matter to be moving. So now it is moved. Wait for some more time.
My lord, when forwarded by white letter, nothing is there, my lord. No, nothing
You
is.
file an RTI, you will get the answer. Wait, we are looking into this issue.
Obliged.
Ms. N. Fukan Lanan, Standing Council, Secondary Education Department, no,
Elementary.
Elementary Education Department submits on instructions that the case of the petitioner on being further processed at the level of the government, the matter is now being endorsed to the Finance Department for concurrence and approval for creation of the post as is required in the matter. Full stop. Accordingly, she prays that the matter be taken up after 2 weeks. Full stop. Prayer accepted. Subparagraph. List this matter again after 2 weeks. On 16/5/2024, on the next day, Ms. N. Fukan shall apprise this court as to the progress as made in the matter. Full stop.
My lord, may I submit a further prayer, my lord? A short affidavit may be, my lord, submitted in the meantime.
Mr. Kadir, we are doing what is best for you.
Obliged.
And once they give it, remind this court, we will have that from the day
Okay.
you ought to have got it.
I know.
That much. I just want this thing to come. I'm waiting for that. Once we get it, we will pass an order that your case having been found, you are entitled from 1/2/2021, right?
My lord,
Deeply
may I pray for a date, my lord, fixed date.
16/5.
Obliged. I know.
Yes.
May it please your lordship.
Where is my note?
It's there in the file. my lord.
You have given.
Yes, ma'am.
Yesterday I could not find it. Where is it? Not to good.
The last occasion I gave extra copy also. ma'am.
That's what. Maybe.
Wait. Maybe in the top of the file.
That's what I'm searching. Memorandum of agreement. Well,
It's salient points of challenge to.
I saw it. I saw it.
Yes.
I know that. This is a part of the order sheets.
Okay.
That is why I missed it. I was searching the whole file yesterday. How long will you take?
No, I'll take not very limited time. I'll just place the papers before your lordships. And at the outset, I'll just try to assist your lordships with regard to the preliminary objection raised by the respondents below. That Sainik school is not a state. They have raised these two issues, and I haven't filed appeal. I have directly approached this court.
Appeal, that is a discretion of this.
That is a discretion. I have got a judgment to that effect, my lord.
There is a latest judgment also on this point.
Did it?
তুমি জনাবা এইখিনি এইখিনি মাৰি লাগিলে মাতি ল'ব ঠিক আছে
First judgment, that is All India Sainik School Employees Association.
no he has given don't go into that point the judgment has come
Okay.
he has also produced I think this is the same judgment 89
No, I think he referred one judgment of RB school.
no 89 89 Raghunath Mishra
Yes,
All India Sainik
para 9.
it's a state
It's a state.
Mr. Kale
Oh, I'm
was fair
grateful.
enough to place that
I'm
the
grateful.
morning.
I'm grateful. I'm grateful.
The army school matter, this was missed out.
Yes.
Yes, Lord.
We relied on the Justice N. Chaudhary when he was an advocate,
Yes.
that judgment.
That judgment.
Basic difference between Sainik school and our school is basic difference is there.
Okay,
Now the
you
other.
can go to the issue.
Yes, ma'am. You will kindly take up the repetition.
Go in details.
Yes, ma'am.
Go from the very beginning.
Yes, ma'am. I'll take, the petitioner, he was initially appointed on 19/9/2005 as TGT Science. And by now he has completed 18 years of service. ma'am.
He is continuing as TGT.
No, by virtue of compulsory retirement, he has been discontinued.
No. He was not promoted. He did not get the PGT post. He is TGT only.
TGT only, same post. Now, your lordship will kindly take up the charge sheet, madam. Page 60, annexure P1.
What happened to the regularization health matters today?
Regularization health.
That matters were there today.
Yes,
What happened? Finished.
finished.
CV.
CAV. I reached a bit late, my lord. The other council was arguing the matter.
Then, okay, disciplinary
Yes.
proceeding, page 60.
Page 61.
Hmm.
May I read, my lord? Para 2. You have been appointed as TGT Science with effect from 19 September 2005. White Sainik School, Gwalpara, later rebid. It has been brought to my notice that your performance so far as has been below satisfactory. This is the contents of the charge sheet, my lord. And your conduct has been poor. And same could be reconciled from the fact that you had been issued with warnings, awarded censure, and counseled many times in the past. So the charge sheet starts with this. So my submission with in this regard would be that the entire proceeding initiated with a preconceived mind. They have already decided that my service was poor, unsatisfactory, everything, my lord. Now, serial number 3, the charges, my lord. In spite of best efforts made by the school to provide you more opportunities to display better academic performance and conduct, you have failed to develop the same. The following other charges are being against you. Number 1.
Proceed.
Failed to conduct annual athletic meet for the academic session 2022-2023. Article 2 charge, you have failed to implement the Atal Tinkering Lab in a reasonable time frame. You know, this is a laboratory to be erected. So they say you have failed to implement the Atal Tinkering Lab within a reasonable time frame. No time frame has been fixed. Article 3 charge, being an in charge of IH obstacle competition, you failed to conduct the event in a befitting manner. Abscess from duty from 18-20 November 2022. You were detailed as duty master on 24 February 2023. You failed to submit the prep report by the day.
What is this prep report?
Prep report is a unofficial report, my lord, which are to be submitted. This is not official. The official report is duty master report. So normally prep report is circulated within the teachers in WhatsApp group, my lord.
What is that report pertaining to?
This is a report with regard to the attendance of the students in the hostel. Prep report is basically preparatory time taken report. It's not official report. It is 6 p.m. to 8 p.m. only once this report is prepared.
Who are there in the hostel?
In the hostel, in the evening. But duty master report, my lord, it is the official report which I am required to submit. That is 3 times a day, my lord, morning, afternoon, then night roll call.
It is called duty master report.
Duty master report. That I submitted. Then Article 6 charge. You had failed to coordinate with other science teachers while preparing question paper. That is 6 Science Periodic Test 3, 2022-2023. Now the statement of imputation, my lord. In order to accord a fair chance to present your case, the details of materials of evidence based on which the article charge frame are given below. See rating. Annual athletic meet for the session 2022-23 was rescheduled due to ATC, IPSC, and you were informed to conduct the event at a later date.
What is this ATC?
ATC is, my lord, this is the. I'll just come to you, Lord Chief.
Okay, you can tell me later.
Annual training camp, my lord. My brother has NCC annual training camp.
Govinda, you are a product of Sainik school. Oh, what is IPSC?
IPSC, which is not. IPSC.
Okay, fine. Then.
Yes.
Forget it, Mr. Das.
Yes,
proceed.
yes. IPSC, and you were informed, Lordship will mark this, you were informed to conduct the event at a later date. You have failed to conduct the competition. B, as a presiding officer of the board convened for implementation of Atal Tinkering Lab, you kept on delaying the matter and even stopped giving regular update on the progress. The IH obstacle competition was conducted in an unprofessional manner. The event was eventually declared cancelled due to indiscipline of cadet and mismanagement by the in charge. Misbehavior by the cadets was also noticed during the conduct. You were detailed on temporary temporary duty to participate in IPSC teachers conclave. I mean, what IPSC is? This is a teachers body. Indian Public School Conference, Milo. You were detailed on temporary duty to participate IPSC teachers conclave scheduled on 9 to 20 November 2022 at LK Singhania Education Center, Gotan, Rajasthan. On 17 November 2022, while traveling, you made a request to Vice Principal to return back on medical grounds. You reached New Delhi on 17 November 23 at 10:30 hours and did not consult any doctor and continued to stay at Delhi and returned to Guwahati on 18 November, very next day, at 20 hours. Thereafter, you consulted the doctor in the evening of 19 November 23 at 1700 hours. You did not contacted the school till reporting back on 21st November 23. You were found absent from duty from school from 18-20 November 22 for 3 days. Now, next charge is you were the duty master on 24 February 23. You were asked to submit the prep report, but you have failed to do so. even after being reminded by the vice principal. Cadet Joshon Boro, who was already having a disciplinary case against him, was found in auditorium on 24 February 23 during inter-house quiz competition. As per the directives, no senior cadet was to be present in auditorium during inter-house quiz competition, including sub-junior appointments. Only one cadet was allowed for photography of the event by Mr. MP Chaudhary. MP Chaudhary was the in charge of that thing. As a duty master, you were not even aware that Cadet Joshon Boro was absent from prep. F. You were nominated to prepare the question paper for periodic test 3, so-and-so. Question paper was found to be out of syllabus. And as a result, cadet could not attempt the questions. You did not coordinate with other subject teacher before preparing the question paper. You are therefore caused to delivery of article of charge as specified in para 3 above, which will be inquired into in due course if warranted, based on the statement as listed in para 4 above. So there are basically 6 charges. But the disciplinary authority during the course of the inquiry, I'm just placing this, disciplinary authority during the course of the inquiry incorporated another charge in the inquiry. No charge sheet.
We'll come to that.
Yes, so that is 7 charges basically total. Now I filed my written statement of defense, and another aspect I would like to draw your lordship's attention. There is no list of witnesses and list of documents along with the charge. There is a mandatory provision under the rules.
Okay.
That IPSC is the Indian Public School Conference.
Oh, he is given.
Now page 63 is my written statement of defense, 7th August 2023. Para 1, I referred to the paragraph 2 of the charge sheet. My contention was that it was already the charge sheet was issued with a preconceived mind. Then para 2, my lord, I have raised this objection that the charge sheet did not contain the list of documents and witnesses. Then my reply.
Reply page 64, third paragraph.
64, yes, my lord. May I read, my lord?
And you can read the third paragraph. Para 3, third paragraph.
Yes, my lord. Para 3. That, sir, the allegations contained in Article 1 charge already form part of the show cause notice dated so-and-so, which were answered in detail in my earlier reply dated so-and-so. And for the purpose of instant written statement, I beg to rely and refer upon the same. In Article 1 charge, it has been alleged that the annual athletic meet for the session 2022-2023 was rescheduled due to ATC and IPSC, and the charge officer was informed to conduct the event at a later date, which the charge officer failed to conduct. That, sir, academic session 2022-2023 means period from 1st April 2022 to 31st March 2023 as per the SSG year planner. The annual athletic meet for the academic session 2022-2023 as per the SSG planner was fixed during the period with effect from 19/12/23. It would be 23, my lord. It's a typographical error. 19/12/23 to 21/12/23. Sorry, my lord, 22. It should be 22 for 3 days. However, in the academic year 2022-2023, the winter vacation was cancelled and the autumn break, Durga Puja vacation was rescheduled as follows. Now, para 4, my lord. That's the academic session 2022-2023. The entire session was packed for academic events, conduct of annual training camp as part of NCC, hosting of IPSC, volleyball championship, because of which the annual athletic meet for the year 22-23 could not be held either in the days with effect from 19/12/22 to 21/12/22 for 3 days or thereafter. Therefore, the allegation that the charge officer failed to conduct the annual athletic meet for the session 2022-23 is absolutely unfounded.
it is stated that if the other events, classes, examinations of the school usurp the pre-scheduled period of the annual athletic meet, as well as period thereafter, the undersigned cannot be blamed. The undersigned is placing the chain of events which contributed towards inability of mine to conduct the annual athletic meet are given below for ready reference. My lord, these are the list of dates. The significant one will be serial number 4. Annual training camp as part of NCC for class 8, 9, 10, 11, and 12 was held from 15/12/22 to 22/12/22. This is in between the 3 days for holding annual athletic meet. And thereafter, your lordship will find each date was preoccupied for various other events.
So you mean to say that the annual meet which was scheduled
Yes,
from 19/12/2022
yes,
to 21/12/2022 because of clause 4
yes,
overlapping
yes,
and the NCC cadet corps training given the precedence,
yes,
this could not be held on that day.
on that day.
Okay.
They allege that it was rescheduled.
So you had time till maybe 31st of March
Yes.
to hold that function again. What happened in between?
Thereafter, my lord, there are other events in the school. So, and their allegation is that it was rescheduled, and in the inquiry report they have come up. One teacher, Mr. Kushwaha, he informed me about the rescheduled date, but that is plain and specifically denied by the petitioner, that he was never intimated. Even
Kushwaha is who? Who is Kushwaha?
he is a teacher.
Teacher. So he was given this information from someone to
Yes.
communicate to you. Who gave
Yes.
him that information?
My lord, that decision has to be by the principal.
Principal. So principal, has he issued any written?
Nothing. Nothing. There is no material. Inquiry officer, inquiry report at least doesn't reveal existence of any material that I was informed about rescheduled date, my lord. Only oral thing.
Okay. Then?
Page 66. Then after the events, the above narration of events examination periodic text would reveal that primarily the annual athletic meet for session so-and-so could not be held because of the annual training camp as part of NCC for class 8 so-and-so, so-and-so, so-and-so was held from so-and-so to so-and-so as per SSD planner. The period fixed for annual athletic meet was with effect from so-and-so to so-and-so. It is further stated that after 22/12/23, there was no space in the calendar to hold the meet for various prefixed periodic tests and examinations in the school as narrated above. Be that as it may, from the aforesaid facts, it can be conclusively construed that the annual athletic meet was the firstly postponed due to the annual training camp of NCC, and thereafter same could not be held due to the various prefixed tests and examinations. Therefore, it is apparent on the face of the records that non-holding of the annual athletic meet cannot be attributed as the lapse of the undersigned. Therefore, no misconduct or efficiency could be alleged against me for not holding of the annual athletic meet during the period so-and-so. Hence, no charge is made out against me according to the allegations leveled against the undersigned in article charge was required to be dropped. Then
all these charges were held to be proof.
This charge is held to be proof only basing on the evidence
of
Kushwaha.
Okay.
Now we come to Article 2 charge, my lord. That is with regard to auto tinkering lab. The allegation is that failed to implement auto tinkering lab within a reasonable time. Now, at the very inception, the charge is vague. They say, I failed to implement. What is this reasonable time? Nothing has been fixed. Apart from that, I'll show what effort the petitioner took for implementation of this lab. So on the face of it, the charge is vague. If you fix a time limit that do it within this 2 months, 3 months, this is the last date, I could have appreciated, yes.
but you will not fix any time and you will make out a charge that you fail to do within a reasonable time. This charge is vague, my lord. Now may I read, my lord? That, sir, in Article 2 charge, allegation has been leveled that charge officer failed to implement the auto tinkering lab in a reasonable time frame. It has been further alleged that the charge officer, as a presiding officer of the board convened for implementation of the auto tinkering lab, kept on delaying the matter and even stopped giving regular update on the progress. Therefore, primarily, there are two components in the charge. First, the charge officer failed to give regular update, and second, the charge officer failed to implement auto tinkering lab. The new committee of implementing auto tinkering lab was formed by order dated 10/11/2022. Prior to that, there was another committee. That committee will not dissolve, then new committee formed incorporating the petitioner. The charge officer was made the presiding officer. Thereafter, various steps initiative taken by the charge officer in implementation of the auto tinkering lab in Sainik School, Gwalpara to demonstrate bona fide discharge of duties by the charge officer are given below for ready reference. Number one, charge officer immediately after taking responsibility as president placed the estimated cost of establishing auto tinkering lab self-sponsored at Sainik School, Gwalpara with recommendations of board on 11/11/2022. The principal Sainik School issued directions dated 14/11/2022 as follows. The board was asked to prepare RFP, request for proposal, and B, administrative officer was asked to confirm the availability of fund for setting up auto tinkering lab. On 19/1/23, the administrative officer Sainik School, Gwalpara confirmed the availability of fund for setting up the auto tinkering lab. The said administrative officer directed the board on the same day to put up weekly progress on establishing auto tinkering lab self-sponsored at school every Saturday. The board put up a proposal on 27/1/23 regarding a presentation on how STEMRobo is a Millard organization or a company which is instrumental in installing this lab. How STEMRobo helps to excel in journey of experimental learning and holistic development of studies by STEMRobo Technologies Private Limited, with reference to email dated 10/1/23 by Mr. Yeshu Joint, Senior Manager, STEMRobo Technologies Private Limited. Thereafter, board tried to contact Mr. Yeshu Jain, Senior Manager, STEMRobo, at his mobile number so-and-so on multiple times and days, but call was not received by Sri so-and-so. The details of communications sought to be made by the charge officer with so-and-so Senior Manager on mobile from 27/1 to 10/3/23 are given below for ready reference. My lord, I have given copies of all these things, my lord. These are the call records, my lord. The board could not prepare the RFP without the list of components items required to set up auto tinkering lab. The board could get the standard list of components items required to set up auto tinkering lab only from a vendor who was listed as an authorized supplier in the GEMS portal. Therefore, in the backdrop of the aforesaid, no weekly progress could be made by the board regarding establishing the auto tinkering lab after 27/1/23. The board sent please call me message at 8:53 hours on 10/3/23 to Mr. Yeshu Jain, Senior Manager, STEMRobo, in his mobile number through WhatsApp. Upon receipt of message, Sri so-and-so shared the contact number of Mr. Anup Gautam, Senior Manager, STEMRobo, with board on so-and-so through WhatsApp message. The board contacted Anup Gautam at his contact number so-and-so on 12/4/23 and reported the matter of unavailability of Mr. so-and-so over mobile phone. Mr. So-and-so informed the board that the Yeshu Jain was on medical leave for 2-3 months. Sri so-and-so also informed the board that MS Kriti Sharma, Assistant General Manager, STEMRobo, will contact the board for further proceedings. The board received call from Kriti Sharma on 13:46 hours on 12/4/23. The board was informed that the delay in communication from the end of STEMRobo will be communicated to the Sainik School, Gwalpara. The board was further requested to finalize the date for the scheduled online presentation how STEMRobo helps to excel in journey of experimental learning and holistic development of the studies. From the sequence of events narrated above, any reasonable person properly instructed in law would come to the conclusion of no lapse on the part of the charge officer in undertaking the process of establishing auto tinkering lab in the Sainik School, Gwalpara. The charge officer acted in proactive manner as president of the board. However, he could not finalize the process because no response from STEMRobo. Therefore, no misconduct can be attributed. So my humble submission with regard to Article 2 charge is that, my lord, there was, if the company which has been identified to install the lab, if that company doesn't respond and there is proof that I communicated with that company in a repeated manner.
Okay, what happened after 12-4?
After 12-4, my lord, 23,
Your charge sheet comes, 21.
my charge sheet comes, my lord. I have,
21-7.
yes, my lord.
And in between, what happened?
Sorry, my lord.
In between,
From
12-4 to 21-7.
my lord, it was processed. The auto tinkering lab, whatever, because after that, my lord, things come into place and it was processed.
Were you submitting reports?
Thereafter, I was taken away from that.
When were you taken away?
My lord, that date I'll have to check, my lord.
Because that allegation can only be till the date you are there.
Yes.
Okay, Mr. Sharma, you make a note of this.
Yes.
Mr. Sharma, you make a note,
Yes.
we'll give us the date.
I'll just,
You proceed.
now Article 3 charge. This is with regard to fail to conduct IH,
Inter-house obstacle competition.
yes, IH obstacle complex in a befitting manner. So Lordship will kindly mark this word befitting manner. That, sir, in article charge, it was alleged that the undersigned being in charge of IH obstacle competition failed to conduct it in a befitting manner. Here it is not the allegations that the IH obstacle competition was not held, but the allegation is that the competition was not held as per the expectation of the authorities. The law is well settled that the failure to attain higher standard of efficiency cannot be construed to be a misconduct. Therefore, even if the competition was not up to the expectation of the authorities, it cannot give a leeway to the authorities to level an allegation of misconduct against me. In the statement of imputation, it was alleged that IH obstacle competition was conducted in an unprofessional manner, resulting in cancellation of the event due to indiscipline of the cadet and mismanagement by the in charge. That was absolutely incorrect. It was held, my lord. In this regard, it is stated that as per the SSG year planner for the academic session 2022-23, the inter-house obstacle competition was scheduled on 25/11/2022. Due to the scheduled NDA National Defense Academy visit of class 9, the inter-house competition was preponed to 23/11/2022. The charge officer proceeded on temporary duty on 16/11/2022 to participate in IPSC teachers conclave scheduled to be held on 19/11/2022 to 20/11/2022. It's a issue. This should have been 2011. At LK Singhania Education Center, Gotan, Rajasthan. However, on my way to Gotan, I fell sick. I returned back midway. After returning midway due to illness, I consulted Dr. So-and-so at Health City Hospital, Khanapara, Guwahati, and on 19/11/2022, and B. Purkayastha Medicine, Maligaon, Guwahati on 20/11/2022. I resumed my duty at school on 21/11/2022. Sir, despite being on medication for illness, I started preparing for the smooth conduct of the inter-house obstacle competition scheduled to be held on 23/11/2022. The Part 1 order promulgating necessary administrative order was published in consultation with the existing SOP. During practice hours, the participating candidates of senior houses were asked to test each and every obstacle, especially those where ropes were used. All obstacles were found in perfect condition without any wear.
You can come to page 72. That's the main portion.
Yes.
Top portion.
Yes. There was one solitary incident. So here, it was not the allegation that some rope.
No, that's your contention.
Yes.
But this is the
primary
defense you have taken.
Yes, Miller.
We have got it. The principal, some students had used some unparliamentary words. Principal heard it. So students were not proceeded, you were proceeded.
Yes, Miller.
You go to 4.
Yes. Then Article 4 charge is with regard to, my lord, absence from duty from 18/11/22 to 20/11/22 when I was sent to IPSC conclave, Gotan, my lord. In Article 4 charge, you are alleged that the charge officer was absent from duty on 18/11/2022 to 20/11/2022. However, there was no allegation that the undersigned was absent unauthorizedly. Therefore, in the absence of any unauthorized absence, no charge could have been leveled against the undersigned for the same period. The present allegations were already appropriately answered in the show cause reply so and so, so and so. I'll just take to the next paragraph. On 16/11/2022, the charge officer proceeded on temporary duty to participate in the IPSC teachers conclave to be held on 19/11/2022 to 20/11/2022 at LK Singhania Education Center, Bhutan. During my journey by train from Bongaigaon to New Delhi, I suffered from serious suffocation and restlessness from Patna onwards. I reached New Delhi on 17/11/2022 at around 10:30 hours, and I informed about my ill health to Commander Naresh Singh Chauhan, Vice Principal, Sainik School, Gwalpara, over phone on 17/11/2022 and sought permission to return back. After getting verbal permission from the higher authority, that is so and so, I returned back to Guwahati on 18/11/2022 by air. I could not attend IPSC teachers conclave to be held on so and so at LK Singhania, Bhutan because of illness. After reaching Guwahati, immediately on the next day, on 19/11/22, I consulted Dr. so and so for further checkup. Thereafter, I returned to Sainik School on 20/11/2022 and rejoined my duties in the school on 21/11/2022. However, after rejoining, I could gather that in the attendance register for academic staff for the month of November 2022, the period with effect from 17/11/22 to 20/11/22 against my name, temporary duty was written. However, later on, the authorities called me and allowed to sign the attendance register on 21/11 and 22/11 by striking of TD for those 2 days. Since in the attendance register for the days 17/11/2022 and 19/11/2022 against my name, it was marked as temporary duty. Therefore, the factum of regularization of leave did not came to my mind. However, it is an admitted factual position that it was due to my illness. I had to return from Delhi, followed by consultation with doctors at Guwahati, which was evident from the various prescriptions submitted by me. I'd just like to point out one thing here. It was not an allegation that I did not attend the meeting.
You came back on medical grounds.
On medical grounds, certificates are there. And for these 2 dates, I have annexed that, attendance
It
register.
cannot be, your contention is it cannot be under any circumstances be said to be unauthorized.
Unauthorized absence. And in the attendance register that I have an attached
Just,
sheet that I
just
have,
rely on a judgment which says that the to be unauthorized absence, the period must be without any justification
yes,
and intimation.
yes,
This is the underlying factor.
this is the underlying factor.
Okay.
And
Now
evidence, the evidence to that effect is the attendance
No, no, we'll
register.
come to the evidence.
Yes,
We'll come to
yes.
the evidence. Just
Now,
this.
5 charts.
Five, I've gone through. 5 here is
Five.
that the head count, one boy was there.
Yes.
So your plea is.
He went to the photography.
But the one was engaged for photography class 10A.
Yes.
The other one from 10C followed.
Follow.
And this was known to Mr. P. Chaudhary.
P. Chaudhary.
He did not make any complaint in this connection.
Yes.
When you took the head count, you found actually 2 students to be less.
Yes.
And the class captains told you that they have gone for the photography.
Yes.
So you bona fide believed it.
Yes.
And with regard to the prep report, you say on that night after the thing was done, you had given the hard copy of the report
To
duty
one
master to the
HLE.
teacher.
Yes.
This is good.
I
Come
given to
say-
one HLE
Ah.
and he was supposed to give.
Whoever it is, you
Yes.
had given it.
Yes, Vinod.
Now, at Article 6.
Article 6 charge is that
Question paper.
fail to coordinate with other teacher in preparing question paper. This is on the face of it.
Wait.
If a question,
How
This
can
is-
you disclose the question paper?
if how can I disclose? And if a teacher is charged for setting up a question paper, then
No,
this is
just tell me, they have said that you have set up question from outside the syllabus.
the question I have narrated.
There is a
There are
part to that.
students who answered this question
You did not discuss one,
Yes.
2 outside the
outside syllabus.
syllabus.
The question was that that I have given: bite, birds migrate, penguin huddle together, polar bear hibernate. This polar bear hibernate, they are saying this is out of syllabus. Even assuming out of syllabus, how can be a charge from this, That is my submission, Then every teacher in the state of Assam, after the matriculation examination or paper setter will get a charge sheet,
Naturally. When I appeared in my exams, I found all the questions to be out of syllabus.
Then
That
all
was a-
teachers,
That was an injustice against me.
I am obliged, my lord.
Now come. to
Now,
the-
in this charge, they come to a conclusion that, yes, I'll just take it
Just
to
that is what
inquiry
I-
report.
No. There's only one question, chapter 7,
Yes,
and then 1E. 1E.
yes.
1E.
Question number 1, series 1, question was define the following hibernation. Now, chapter 7, whether so-and-so NCERT textbook class 7 subjects.
Okay, got it. Now come to the main part.
I'll come to the inquiry report. Prior to that,
Hmm.
I'll just place the genesis of article charge number 7. There is another charge they have incorporated.
Where
7.
was it given
Yes.
in the form of a letter?
No, how this 7 charge started.
That you should.
Yes, on my lord, after filing of the written statement of defense,
Hmm.
on 7/8/23, that your lordship will come to page 77.
Hmm.
I submitted an application for earn leave
Hmm.
for 8th to 9th.
Hmm.
Reason, medical treatment of my wife in Guwahati. Actually, my wife was suffering from some serious stomach pain.
Hmm.
It was going on for quite some time.
Hmm.
So I wanted to take her. I showed it to Gwalpara doctor, but she was not recovering. So I tried to take her. I wanted to take her to Guwahati.
Hmm.
So I submitted an application.
Hmm.
Now, down below in middle portion, lordship will see senior master recommended.
Hmm.
And VP, vice principal, he not recommended.
Is there a type copy of this? Teacher left the school one day.
Yes, teacher left the school in 1 day in advance without informing. I'll give a better copy, my lord. I'll just try to give I'll give a type copy.
Hmm.
So this was the endorsement of the I think office superintendent, my lord.
Hmm.
And down below, there was another endorsement of principal, my lord, that is eligible. I'll try to give a
That
type
was-
copy. Yes. So whatever is there, my lord, I submitted this application. Then on 7/8/23, my lord, I leave the school because my wife was having serious stomach pain. Although I prayed for 8 to 9, I had to leave because of the medical emergency.
Hmm.
And admitted her to Health City Hospital,
Hmm.
wherein the doctor on the same day itself undergone its surgery, my lord,
Hmm.
major surgery.
Hmm.
And the surgery was held on 8/8/23.
So you asked for a further extension of
I
that.
asked for a further extension on 9/8/23. Kindly extend my earn leave for another 7 days from 10 August to 16 August.
Hmm.
Then my lord will come, page 79, show cause notice.
Okay.
No, show cause notice is like, my lord, Saturdays and Sundays in Sainik school. It's like, my lord, I am working not in Sainik school, I am working in Jammu Kashmir border, my lord. I know the principal is from defense
Maybe
background, my
you
lord.
are also the King Jolokia.
He is upright. He is upright, my lord. That I can say, my lord. He will not bow down to anybody. That my lord,
No,
person
that is a
have,
good nature, but sometimes the other way
but he is
also.
not rebellious, my lord. He is not rebellious.
Okay.
Lordship will see from his replies,
He
inquiry
is
officer's
very,
reply,
very calm, very sober replies.
sober replies. He could have said many things, but he always
Teachers
folded,
reply.
yes, folded hands.
So what happened here? You were put
Here-
in on leave without
yes.
approval of the principal violated.
So and so, you were found missing on so and so, leave without proper sanction, so and so. Displays arrogant, anti-institution, selfish, lackadaisical attitude towards the school. So this was a show cause. And why should not be terminated? Your service should not be terminated. The intention is very clear. Now I submitted a reply. I filed an application seeking for photocopy of the leave application. Previous leave application. My lordship can skip this, my lord. Because the leave application that I showed to you, that was given to me after this application.
you collect the information in the main office. Then, my lord,
84 is the reply.
yes. '84 is the reply, my lord. Down below, serial number 9. I humbly want to submit that my wife underwent open surgery of appendicitis on 29th of May 23 at Solas Hospital, Gwalpara. The open surgery was performed by Dr. So-and-so. Everything was going on well on till 2nd of August 23 around 2 hours. When she started complaining about the development of pain on right abdomen, she also started vomiting. The matter was reported over phone to so-and-so on 2nd of August. He diagnosed as gastric problem and advised tablet, but both the abdominal pain and vomiting persisted during 3rd of August. I took my wife to so-and-so again tablet. Meanwhile, I was detailed a board on 5th of August 23 to prepare the AWL prolonged absent cadet details after collecting from all housemaster and to prepare a minute sheet of SOS from the school to submit the board proceeding on 7th August 2023. I did my duty and thereafter I left. As I was the only member of the board, I was left with no option but to plan my wife's treatment in Guwahati on 7th August 23. On 7 August 23, before the principal's assembly in morning, I apprised the vice principal, sir, about the ongoing health issue of my wife and expressed the requirement of leave for minimum 2 days. I also informed him that I had to submit a board proceeding of AWL, prolonged absent cadet list of SOS for SOS from the school on the same day. During my conversation with Vice Principal, Senior Master Sir was also present. Vice Principal Sir told me that he will let me know about grant of leave post discussion with Principal Sir. Vice Principal Sir also directed me to proceed on leave only after submission of the board proceeding of AWL prolonged absent cadet list for SOS from the school. Meanwhile, I continued performing my academic duties of the day. Simultaneously, I also started collecting signature of the house-masters in the board proceedings of AWL prolonged absent cadet list for SOS from the school. During tea break, I went to show the board proceedings of AWL prolonged absent cadet list for SOS from the school to the Vice Principal Sir. I was told by Vice Principal Sir that he discussed my request for leave with Principal Sir and permitted me to put up my leave application. Subsequently, I put up my leave application at around 12:10 hours, applying earned leave for 8 and 9 August 23 with permission to leave the school campus on 7/8/23 at 14
Yes,
hours.
sir. That's
Yes.
fine. We have got it. Now
Yes.
we come to page 88.
So this was purely due to the sickness. Now page 88, this is one of the impugn order, my lord.
Now, this was also a part of the main inquiry proceeding.
No.
This aggregation was not a part of the.
No, not a
they
part.
in between they have issued this and they have imposed a diasnon on it.
Diasnon.
So then why have they not resorted to the same method with regard to your Delhi trip?
Yes.
This is more serious than that.
Yes.
Therein you went with permission. Yes,
Yes.
Mr. Kal. Just a query. If for Delhi, that IPSC conference he had gone.
Yes.
And you have held a meeting, a proceeding against him. This is a more serious offense. Right? Why was the diasnon? Because diasnon means everything gone. It's a major penalty. If you look into it, because diasnon would result in the service prior to that, gone. Break-in service.
That is.
Why was the proceeding not initiated?
I'll consider the record.
Yes.
So they have declared that period diasnon. Then I submitted a application to review that decision, page 89, withdrawal of diasnon. Then they passed this order at page 90. They send this issue directly to the inquiry committee without Milord framing a charge. Milord, God knows what procedure they have followed, Milord. If you want to proceed in this matter,
draw up a fresh charge.
You have to draw up a charge. You have to give me opportunity to file written statement of defense. Nothing was given. Directly incorporated this allegation in as Article 7 charge, that too in the inquiry report.
Interesting.
Then the formation of the inquiry committee, your lordship will find page 92.
That you have no allegation.
There is one relevance here, my lord, because there was no presenting officer appointed in the inquiry.
Okay.
So the records will reveal, lordship will get this from the records. Most of the questions as well as cross-examinations were done
By the inquiry
by the
committee.
presenting officer and member one. Presenting officer, that is the
Presiding
right,
officer.
presiding officer, sorry, my lord. Presiding officer and M.K. Singh, the senior master. And the interesting procedure was followed, my lord. I have got a judgment to that effect also, to say, make submission that the entire inquiry from its nature, that is vitiated. That your lordship find from the records.
They
What
can ask for clarification.
What they have done.
They can conduct the inquiry.
No, they cannot conduct it.
They can
They
can
have
ask
become
for
judge-
clarifications.
They have become judge of their own cause. What they have done, my lord, in the inquiry, no, my lord, communication was issued to a particular witness 1 or 2 days prior. No, nothing was done. Lordship will check the records and perhaps lordship will find. That is my instruction. What they have done, suppose the teacher is doing a class, inquiry committee is sitting, they call the teacher from the class and they take whatever their questions, they ask the question to the teachers. Who were, my lord, arrayed or who were, my lord, whose statements were relied on against me. Then, my lord, when they asked the question to the teachers, I was allowed to move out of the room. First floor. First floor. That your lordship will
No,
get.
Mr. Kayal has said that this allegation you have brought in your rejoinder. And he said that is wrong because they are videographed the entire.
If I am wrong, my lord, I will accept. This is my submission only. That your lordship will find from the records. That is my instruction. That's why I am placing. They have moved me
Was
out.
daily order sheets prepared?
No copy of daily order sheet given to me.
Okay.
It's their duty. That is also another aspect, my lord. So they asked me to move out of the room. They took the statements of the teachers. They left them. Then I was allowed inside the room. The two persons, presiding officer and the member one, they asked me questions. They cross-examined me also.
You were not allowed to cross-examine the others.
Yes, thereafter, the witness, he was brought in the, my lord, inquiry room, and I was allowed to ask questions to him. It was not a cross-examination.
Now, tell me one thing.
Yes.
You said at the first instance that the statements were not made before you.
Yes.
By the witnesses.
Yes.
How did you cross-examine them?
It's impossible to cross-examine. First of all.
Have you taken a plea to that effect?
Yes, my lord. I have
In the
taken,
petition.
in the, my lord, region affidavit in reply, I have taken this plea.
Why not in the written
My lord,
petition?
In the writ petition, the problem is that, my lord, since my lord, he is not a legal person, my lord, I will have to, my lord, ask questions to him. When I ask questions to him after the thing that how did the inquiry proceeded? No, he is not a legal person that he'll know this will be important, that will be. I asked him questions that tell me about how the inquiry proceeded. Then he showed me.
Another
Otherwise,
query.
also, lordship will find
Another
this.
query, another query.
Yes, my lord.
Normally, a list of documents are not there. A list of witnesses are not there. That by itself may not be very vital.
No.
No.
Yes.
May not be very vital.
Fine. I'm sorry.
You have to show a prejudice to that extent. But at least before the inquiry on the preliminary inquiry date, it is duty bound that they prepare a list of witnesses they want to examine and then disclose that to you. Have they done that?
No.
No.
Look, they randomly call the.
I'm just trying to refine that.
I understand, Milo.
Maybe they have not annexed a list of witnesses, a list of documents.
They have to call the witnesses.
They have to
They
make a
have to-
list first. Say
Yes.
that this is the list. What is your list?
Yes.
At least that much of procedural thing has to be followed.
Follow.
You mean to say that was not?
No.
When the inquiry committee sat, randomly teachers were called.
Okay.
And why I say so, my lord, that list of witness and list of documents are required. Lordship will kindly appreciate one thing. This is not a simple exercise. Charge sheet is a serious business, my lord.
Mr. Counsel, I know the law. But I was trying to understand whether they might not be knowing that this is the format to be done. I'm giving them that leeway.
Fine.
But at least once they have sat as an inquiry committee, two things must be very, very clear. One, the documents that would be relevant for the charges, that should be with the committee or the person presenting officer. That is the role of the presenting officer.
Exactly, my lord.
He has to have all the documents which would be relevant for proving the charge.
Yes.
Two, the inquiry committee must know, along with the delinquent, that these are the witnesses who will be called.
Yes.
So that you can form your idea that this will be called for this.
Yes.
So I'll hear him, so I'll cross, because you may be required to cross immediately
Yes.
on the same day.
Yes, my lord.
So at least if you know that this teacher is coming, this teacher is coming, you can make out an idea that,
Yes.
okay, fine.
That is also one of the opportunity.
Opportunity.
That is one of the opportunity.
So even if that opportunity was not given in the, which is the law, it
Yes.
has to be there in the show cause should be there. The show cause, list of documents, list of witnesses must be there. But they don't know. They don't know. But before sitting, they can come in the morning and say, no, today I will examine Ms. Gayan. Tomorrow, Mr. Das, then Mr. Sharma. Then they say Mr. Cal. Then they come, no, we'll ask the judge also. They can't do that.
They can do that.
So that is what the procedure there.
Yes.
Okay, understood.
Mm.
What
So-
is the charge now? What is the findings?
Yes, so this is the 92 is the formation. Then
Before you take me through the inquiry report, take me directly to that charge number 7.
charge number 7, how they prove in the inquiry. Yes.
109.
100 and no,
Page 100.
charge number 7, Lordship will find page 120.
No, what
Oh,
is the?
sorry, my lord. Yes, 109, correct, my lord. 109, my lord.
Hmm.
Additional article of charge 7, case of absence from duty from 7 August to 16 August 23, while later dated so and so. Findings. On 7 August 23, around 7:30 hours, when vice principal was waiting to receive the principal for principal assembly, charge teacher approached and requested for 2 days leave for treatment of his wife in Guwahati. Vice principal asked him to go on leave since it was stated as a medical urgency. However, charge teacher stated that he has to submit one assigned task AWL board today, being the last day of submission. He also stated that the board is ready and he has to just submit it. Accordingly, the charge teacher was told that his leave requirement will be discussed with the principal and he'll be informed accordingly. Around 1100 hours, charge officer was informed to put up the leave application for approval. When came to vice principal's office during tea break on the same day, subsequently on so-and-so hours, Mr. G. Deka submitted his leave application and left the school on 13:35 hours without informing anyone and properly handing over of his duties and classes. Board has found the charge framed against the teacher valid. Following are the points submitted in support of board finding. Charge teacher is very well acquainted with the extant orders for teachers while proceeding on leave of any nature, which has been assigned by the charge teacher on 18 January by ION dated so-and-so Sainik School Society's rules and regulations. The senior master also keeps frequently reminding this rule to all the faculty members, most recent on so-and-so. Board has also found the charge teacher is frequent leave seeker and availer. This is they're relying on past charges. Charge teacher added on the leave application with permission to leave the campus on 14 hours on 7 August 23. However, no specific permission was taken with respect to this. Eventually, charge teacher was found absent from regimental lunch of outgoing admin officer on 7 August 23.
Charge teacher claimed that his wife is very serious and need immediate medical attention of a specialist in Guwahati. Teacher was told to go in the morning itself by the principal. However, he preferred to stay back till 13:35 hours. The same has not been found logical by the board. Charge teacher has been found involved in akin cases in 2008, where he had also left the school in similar manner, citing the medical emergency of his parent. In this connection, with which he was awarded censure by so-and-so. Charge teacher has a tendency to seek leave citing medical sympathy. The individual has failed to take approval from principal even after remark to meet principal on leave application. Charge teacher failed to meet after joining the school.
Mr. Das, page 110, 1 to 8. 1 to 7, then page 111.
8.
These are the findings of the board.
Board.
Sure.
Yes. Yes.
Yes, board. Read 5 again. Roman 5.
The charge teacher claimed that his wife is very serious and need immediate medical attention of the specialist in Guwahati. Teacher was told to go in the morning itself by the vice principal. However, he preferred to stay back till so-and-so. The same was not found logical by the board.
What do you mean? What do they mean?
I am saying so. AWL, my lord, lordship will remember, I read the thing.
You had to prepare, so you
Attendance
were
list.
running around.
Yes, I was running around. I said that I am the only person, authorized person to do that. So I'll do that. And thereafter, I left the school because she was having pain. I completed that task and thereafter I left. So this is again turned around me saying that you were asked to go in the morning. You wait till
No,
13:35.
there's conclusions that are there other than para 5.
Yes.
The others don't, other paragraphs 1, 2, 3, 4.
Most of them were not the
6,
allegations.
7.
Yes.
And 8. Okay, forget 8 till 7.
Yes.
Does not deal with the charge.
No.
Per se.
Yes.
It deals with something else, general.
Past charge and other his tendencies.
One is that general thing, everybody knows about it.
Yes.
2 is senior masters recommend.
Yes.
3 is your general.
Yes.
Your history.
Yes.
Then it says
regimental lunch.
With permission to leave campus on so and so. However, no specific permission was taken with respect to this. Eventually, now tell me.
So they
these
say
findings.
I'm sorry.
These findings are recorded on what basis? What is the basis of these findings?
Because no material was given to me. Nothing, no daily order sheet on this.
Because somebody must have produced before the board this 18 Jan ION. Then the WhatsApp group printout.
These things were taken by the inquiry committee from the school record itself.
It cannot.
It cannot.
How can it do it?
That's why there is another legal ground I have taken on this.
Where is the daily proceeding sheet, Mr.? Just show me.
And one important aspect, my lord, my wife was suffering from pain. She has undergone surgery. I'll wait for regimental lunch, my lord. Is this a sense?
No, it would have been a different aspect if you had not submitted that application.
And I have.
And I was looking through this, that whether there is a finding that you had resorted to misrepresenting. Your wife was not sick. Something of that sort. It's not there.
That's true.
Yes, show me the daily order sheets.
And even I submitted medical documents also before the authorities.
So just take me fast through that finding with regard to charge number 1.
Yes, madam. 102. Findings, my lord, with regard to charge number 1, page 102. First line, the charge teacher has accepted that he did not conduct the annual athletic meet for the academic session 22-23. The first line, I admitted the charge.
The board also found that in spite of being very well aware of the date already promulgated for conducting annual athletic meet, the charge teacher did not conduct it even after rescheduled dates were informed to him by Mr. A.K. Kushwaha. Mr. Kushwaha has explicitly stated that the events were rescheduled after approval from principal, and each and every teacher in charges whose dates were rescheduled were informed. Charge teacher failed to conduct the event on rescheduled dates, whereas all other in charges could conduct and finish their events as directed. The charge teacher neither approached the authority for cancellation of the event, nor he informed anyone about the non-conduct of such a major training event. In fact, the charge teacher preferred to remain silent till he was show cause. The board also noticed that the claim of non-availability of dates to conduct the events on rescheduled date have been found invalid. The following points are submitted with regard to non-conduct
Now
of
come to clause 2 there.
clause
Page 103, clause 2.
2. No permission was taken to cancel the event from principal.
Now, the charge is, it
Failed.
was rescheduled and you had not held the event in the rescheduled time.
Yes.
This is not a
No.
allegation against you.
No. Individual himself decided not to conduct it and remain so and so. Then four, your lordship will see, individual also claimed that he was not aware that he was the teacher in charge of so and so. He only had come to know the school diary so and so. The claim of the teacher has been found false. You know, these are all beyond
That
charges.
is not
my
your
lord.
stand in the written statement.
No,
Written statement.
these are all beyond, all alien things were incorporated in the inquiry officer's report. Then next, my lord, I'll take Atoll Tinkering Lab. Again, the first line, the charge teacher has accepted that he failed to implement the Atoll Tinkering Lab in a reasonable time manner. As per the board findings, implementation of ATL board was constituted by.
Okay, Mr. We got it.
Yes.
The next please.
Then.
This is the order sheets. Wait, let me just go through the order sheets.
Yes. Then Article 3 charge.
We've got it, Mr.
Yes.
Thus, we've got it.
From 37, that is the daily
Order sheets.
my orders.
You're Gautam.
Gautam data.
Yes, Gautam. There is a flag mark against the each side, smaller. Dean flag mark.
Where are the other witnesses, Miss? Okay, questionnaire with so and so. What is this process you have done? Where is the signature of the delinquent here? Delinquent signature in Kushua. So his allegation is that Kushua was examined behind his back. Right? You can dispel that allegation if you could have shown, like in the statements of Gautam, the petitioner, his signatures are. In the inquiry with regard to questions made to Kushua, only the signature of Mr. Kushua is there, nobody else.
But in some pages.
And very interesting. You have written here questions by the PO. The PO is asking making the examination. How? How can the PO make he is the judge. He's the judge. How can he make it? You're right. Questions
there.
put by.
Yes.
PO. These are elementary. Please don't mind
Yes, ma'am.
the anxiety of this court or the maybe a little bit going ahead. But these are elementary things in an inquiry. You cannot ignore this. The signatures, these are the basic things which shows how the process, how the inquiry was conducted. Okay, we'll then go further. Mr. Das,
Yes, my lord.
what more?
My lord,
The decisions.
yes. Three charge, other charge 2, 3.
I've
My lord,
got
with regard to, my lord,
all post conclusions. At least
Lordship will
what
kindly
Mr.
check with the records with regard to Article 3 charge,
Hmm.
105 page.
Hmm.
There is a statement or there is a finding by the inquiry committee,
Just so.
page 105. Correct.
105.
105. Lordship will check from the records whether this is correct, but my instruction, I have taken a stand also. This opportunity was never given to me.
Which one?
Okay, what do you want to show here? Following points.
So Roman 5. After cross-examining from P.K. Odhikari, S.M. Roman and Sanjoy Deka, it was found that the event was not conducted in a befitting manner. So what does the inquiry committee mean? I don't know whether they are examining or cross-examining. My understanding is that they have examined these 3 persons. I never I was allowed to
No,
cross-examine.
that is evident that Kushova,
Huh.
your signature is not there.
Yes, Milo. Similarly, Milo, these 3 persons, I was never confronted with these 3 persons.
Wait,
Milo.
just a moment, just a moment.
Their statements are available, the statement of these persons are available on the record.
I'm just going through them.
Yes.
Where is it?
Charge number 3, Milo.
No, the statement of Bormon. MK Bormon.
Oh, no, Milo. P.K. Odhikari, S.M. Roman and Sanjoy Deka.
There is a green flag mark, my lord, inside against the charge number 3, my lord. Charge number 3. That is.
This one?
May I?
Yes. Definitely. Mr. Cal, you will have to show me something now.
I understand it.
I'm not with the conclusions. I'm with the procedure.
That
The
is,
manner in which it was done.
the flow is there, Lordship. It is
Not only flow. That charge number 7, the manner in which you have proceeded, that itself vitiates the rule. Now, Dyson plus this penalty. Dyson is applied to him. And now again, after this compulsory time. Mr. Das.
Yes, Malik.
Just see that statement. We'll ask Ms. Gayan to give you access to the records.
Yes.
Make your notes.
Yes.
So it cuts the matter.
Yes.
But as a Katsi Sheikh, whatever you find,
yes,
please disclose to Mr. Kaya
Definitely.
also.
Definitely.
Not adversary. We are trying to find out a solution. Please tell him also.
Yes.
So that he can also formulate the answers.
Apart from being a counsel for the petitioner, we are also officer of the court. Miller.
I'm
look up to
doing that
senior.
for my selfish interest.
Milord,
Otherwise, Mr. Kel, with this,
I understand.
my limited knowledge,
After going through,
this cannot survive.
I myself conducted many inquiries, Lordship.
Now, you know.
That is, Lordship, nothing to hide.
See, the records of an inquiry discloses the manner in which the persons are thinking. This is not an inquiry to find out the fact. This is an inquiry, tentative view that I am taking. This is an inquiry held to punish him. Not to find out the... Okay, what is the disciplinary authority's order here?
Your Lordship will find penalty order.
Any discussion?
No. Nothing, Milord. Page 132. I'm seeing. Wait. Another way. PK Odhikari.
SM Rahman, Sanjay Dekar. Page 132. The very elementary principle of departmental proceeding, good and sufficient reason. Rule 11 in our CCA we follow. Penalty can be imposed for good and sufficient reason. Their rule 10.1, my lord.
Now tell me, who is this higher authority?
The higher authority is the BOG.
And an appeal in this connection will lie to the BOG.
BOG. In the meantime, my lord, there is a system that before imposition of penalty, I can request for a meeting with the BOG in the GOC. So that option I availed. I was given a meeting with the
BOG.
Yes.
And then you
Then
explain.
this penalty order.
Now tell me, if the appellate authority has already applied its mind to the inquiry report and then permitted this, how can an appeal be taken up by that same very authority?
They say that there is another hierarchy, that is the Defense Secretary, New Delhi.
For a teacher?
For a teacher. They say the next, next higher authority.
How?
Since appellate authority has seen or he is.
No. How can the Defense Secretary be the appellate authority?
That is the hierarchy they are saying.
From where?
And in the affidavit.
From
they have,
affidavit they have said.
in rule. And affidavit also they say that initially the principal wanted to dismiss me from service. The initial decision of the principal was dismissal from service, but after the BOG's consultation, he has changed it to compulsory retirement on these allegations.
This in rule is in I have annexed in my affidavit in opposition 216 page number regarding appeal.
Where is this PK Odegari?
Sorry, Miller.
No. PK Odegari statement.
That is MK Singh, my lord. Kindly give me some time. I will flag back all this. Kindly give me some time. I will flag back all the statement.
You do that. We have got it. You do that. And do one thing. You give him access.
Yes.
Let him make his notes.
Notes.
But don't leave the file with him.
This code can have that fate.
I don't want that fate to be broken.
No, it will never, Miller. Not only
Come on.
this code,
That's
any code.
just a.
Yes, Miller.
Okay. Mr. Cal,
Not sir.
reserve your strength. Let him go through the records.
Yes, sir.
Just give me a small note.
From the records, I'll just prepare a small notes referring to
Now
the page
do
number.
a thing for me, exercise for me. Charge your reply, gone through, inquiry officer's concrete finding, and in the report, representation against the inquiry report, where you have dealt with. Each charge, give me a table.
Yes.
And Mr. Cal, Mr. Gan, you also do that.
We'll do and
That too, you give it to me, and then you take up whatever plea and the statements. Next day, I'll reserve the judgment.
not.
Mr. Cal, try to find out something.
I have understand also.
Unfortunately, I have to take this tentative view.
We have also discussed, I was also discussed my landed friend.
Why don't you withdraw that? Withdraw that. Withdraw this proceeding. I'll permit you to, if required, I'll permit you.
I'll talk to.
I'll permit you.
Yes.
But the charges that you have leveled against him, if I have to go into the merits, which maybe I don't have the power, but in a given case, I can go, it will be perverse. At least that charge of Delhi and the wife, gone. Charge number 1, not very satisfactory.
But after going through the records, I find something that can be argued.
Yes, please.
But regarding other things, probably procedure for conducting the civil body, they have not followed anything. That is apparent on the face. of it.
Earlier, I was under the tentative opinion that we have to go into the question of proportionality here. But here the findings that are there, the
No,
whole
that is-
charge is going, proceeding is going.
I'll-
If he has committed any misconduct,
I'll talk to the,
Mr. Das, you also address this court with regard to at least certain charges, whether that would constitute a misconduct.
Yes, my lord. I can address, I'll address, my lord.
With regard to holding of the meeting of that event
Event. yes.
cancelled. The charge is something else. The finding that has been finally arrived is something else. And the only link they are trying to do is Hushuva.
Pushpa.
And this court is satisfied that Hushuva, while he was examined, you were not given access. And I don't find that his statement's copy was given to you.
Apart from that, perhaps your lordship will not find any document in the record
No, I don't,
by
because
which
I know
they
my,
claim.
that side the power was much greater. But when I come this side in a departmental proceeding, my powers are curtailed. I'll have to only look into that procedure. part.
procedural and others.
But
No,
in a given case,
one aspect, my lord. Procedure is there, but there is a very thin line of difference in a departmental proceeding between an evidence and a relevant evidence. A relevant evidence will be, my lord, which will have to be proved by it. An evidence to become a relevant evidence, that there has to be proof of that evidence. Otherwise, it is not an evidence. Sorry, my lord, otherwise it is not a relevant evidence.
what you're trying to tell
Yes.
me is, say there is a document.
Yes,
This document has to be produced by somebody
yes,
who knows about it.
yes.
He may not know. That's a different thing altogether.
Huh.
But legally, presumption is that person producing the document knows about it. So when that document is produced by him, it is taken on record. So the document existence is proved. But the contents are not proved.
Exactly.
Contents are not proved. LIC's case, Rup Singh Negi.
Yes.
Contents are not proved. Contents, he will have to tell, sir, see, from this document, this man had proceeded with this application. He did not tell anything. Thereafter, we were giving him letters after letters. He was not responding. So these are the proof with regard to contents. Now the delinquent can't question the document. He'll not get anything. That's a dead thing. He will question the man who has produced it from his statement. So that document, if he cannot dislodge, it becomes evidence. Now you take it and proceed.
So if the inquiry officer or inquiry committee, before the inquiry committee, there is no relevant evidence which has been proved in this manner, then the findings are perverse. This is a settled position of law.
Here, we need not even go into that stage because here the examination subject to you going through the records, complete examination was made by the presiding officer.
Yes.
And maybe one more else. If that be so, what sanctity is there?
No, that's the law.
It cannot be. It has to be by the presenting officer and he is a judge. But like in the Evidence Act 165, court can
put
questions. The inquiry officer can put questions.
Yes.
But those are with regard to clarifications, not to get the original
answer.
No, that is in Omparkas, probably Omparkas Sarma. Therefore, our High Court also, Justice Chaudhary has.
Many judgments are there.
Not that.
Recent judgment, I think, of Justice A.D. Chaudhary is also there on this point.
There is one.
When we'll not put it further. We'll have it on Tuesday,
Fine.
2 p.m. Tuesday, 2 p.m.
Tuesday, 30th.
30th. Any problem?
No, Lordship has fixed some universities matter.
Oh, that I have already. This I want to go a bit more into.
Lordship, if you Lordship allow, we can produce that video recording also.
No, I don't want to look into it. Do one thing. The relevant portion that he is questioning,
Yes.
that he was not there when the witnesses were examined. Why don't you share that with him?
That we can say with him.
If you both agree,
And furthermore,
what should I say?
whatever Lordship suggested, we'll talk to the principal. If he is agree, then
But Mr. subject to Mr. Das making that submission, making that argument with regard to the question of being misconduct borne out from the charges that have been framed against him. If there are charges, if that situation arises, I think this court will also have to look into allegation that he would, or the argument he would develop, say charge number 1. If this court finds no, a misconduct is not borne out, then you can't proceed. But charge number 2, 3, 4, yes, there is something you can proceed. Proceed in a manner known to law with regard to those charges, no problem. But this entire exercise that you have done has to be undone.
Now that we'll obtain instruction if we
Yes,
declare, then it will.
Mr. Das.
I'll make my submission, my lord, on the no misconduct also and on the ground of perversity also, because prima facie, my lord, my understanding.
Because see, the charges, 7 charges, 7 though, it's not even worth considering. Other 6 charges, 3 maybe, yes.
Something is there.
It would be the other side of the border. Means no misconduct. But 3 may be bordering on a misconduct. That this court cannot go into.
Wherein I'll take your lordships with the perversity.
Okay.
Then also your lordships can go into it.
No problem. In the school, they are continuing
Yes,
with the matter.
since the vacations are now going on, my lord, till May, I think 15 or 20.
Heard the parties at length. Mr. H. Das, HK Das has made his submissions which remain inconclusive. So, Ms. A. Gayan is required to grant access to the records to Mr. Gayan, to Mr. Das at a time convenient to them. And Mr. Das on the next day shall, basing on the examination so made of the records, submit a detailed note, a small note thereon before this court. Mr. Cal, learned counsel, who also had interacted with the court during the present proceedings, during the hearing of the matter, shall also bring on record a note with regard to the manner in which the charges were proved in the inquiry. That is to say, the evidences basing on which the respective charges number 1 to 7 as leveled against the petitioner herein was so proved, was so held to be established, proved, no? Held to be established. 30th at 2 p.m.
No, fine.
File to move.